Good morning. I'm Carl Reeves, Chair of the United States Sentencing Commission. I welcome you all to our fourth and final day of hearings on our current slate of proposed amendments to the sentencing guidelines. Some of you have been with us at each hearing, and I appreciate that. Others may be joining us for the very first time, and I appreciate that as well. Regardless of which group you fall into, I thank each of you for joining us, whether you're with us in this room, or you're with us at your desk, or you're with us wherever you are via live stream. I again have the honor of opening this hearing with my fellow commissioners. To my right, I have Vice Chair Claire Murray, Vice Chair Laura Mate, Commissioner, Claria Boone, and our ex officio member, Jonathan Wroblewski. To my left, we have Vice Chair Louis Felipe Restrepo and Commissioner Candace Wong. John Gleason, as you see, his chair is empty, but he's in the room with us via phone. We appreciate all the commissioners and the work that we've done. The commissioners are not the only one who are working, however. We also have a deeply dedicated staff. All of them, some of them present in this room, others are working elsewhere. They have worked tirelessly to make this day possible. I want to thank them again and again before this audience and every audience that I speak to for the work that they do, for the work that they are doing, and for the work that they will continue to do. We appreciate you, and I say that on behalf of myself, and I say that on behalf of every commissioner along this table and even on the phone. While our hearings may be ending today, our need for your input is not. We will continue to accept public comments until March 14th. Panelists, if you will come away from today with more to say, please provide us with your supplemental testimony before the deadline. I also urge members of the public to submit comments by way of our online portal at www.ussc.gov. However and whenever you speak to the commission, you will be heard. Yesterday, we heard testimony on proposed amendments regarding firearms offenses, drug offenses, and resolving conflicts among the courts of appeals. Today, we will be taking testimony on proposed amendments regarding the career offender guideline and how criminal history is addressed in the guidelines. While these are the last proposals discussed at our hearings, they are just as important as our other proposed amendments, as the testimony of today's esteemed panelists will make clear. Panelists, thank you for being with us today. You will each have 5 minutes to speak. Know that we have read your written submissions. Your time will begin when the light turns green. You have 1 minute left when it turns yellow, and no time left when it turns red. If I cut you off, please understand, I'm not being rude, as we have so much to cover today as we have had to cover in past days, and we have a limited time to hear from everyone. For our audio system to work, yesterday I think we've ironed out all the glitches. For our audio system to work, though, you'll still need to make sure that your microphone is on before speaking. Look for the green light. And you'll also need to make sure you're speaking as loud as I'm speaking now, and speak directly into the microphone. And don't be shy about leaning in and getting close to the microphone if necessary. When all panelists have finished speaking, I'm sure our commissioners will ask questions. For the past three times I said may ask questions, but we've asked questions every time. So I can guarantee you we're going to ask them questions. So thank you for joining us, and I look forward to a very productive hearing. Now, point of personal privilege again. You know I have to bring up Yazoo City. Well, I learned yesterday after the close of the hearing last night, the basketball team that I was telling you about, they were the 4A champions. They have been named the #1 team in the state of Mississippi among all the divisions. Congratulations, Yazoo City High School boys 4A team, who are the #1 team in the whole state of Mississippi. Congratulations to you, Coach Anthony Carlisle. Thank you so much for what you all are doing for my hometown. I certainly appreciate that. Now, that's a great way to start, right? Follow that, Mrs. Osmond. All right. With that, I'd like to introduce our first panelist, who will present the executive branch's perspective on our proposed amendment regarding the career offender guideline. We have with us Robert A. Zalzmer, who serves as Chief of Appeals in the United States Attorney's Office for the Eastern District of Pennsylvania. Mrs. Zalzmer has served as the chair of the Department of Justice's Appellate Chiefs Working Group and as an ex officio member of the Attorney General's Advisory Committee. Mrs. Zalzmer has spent over 30 years working as an assistant U.S. attorney in Pennsylvania. Mrs. Zalzmer, we're ready to hear from you whenever you are, sir. Thank you.
Thank you, Mr. Chairman. I don't know if I can follow on the success of the Yazoo City High School team, which I am delighted to hear about, but I will turn to the matter at issue here. Chairman Reeves and members of the Commission, thank you very much for the honor of appearing before the Commission and for the opportunity to present the views of the Department of Justice regarding proposed amendments to the career offender guideline. I have served for 25 years as the Chief Appellate Attorney in my office, and in addition, during the past 15 years, I have provided input to department policymakers and guidance to prosecutors nationwide regarding sentencing issues. In my various roles, including in my service as the pardon attorney in 2016, I have seen firsthand the broad and legitimate concerns about severity levels associated with many recidivist provisions, including in the guidelines. Indeed, the Attorney General recently encouraged prosecutors to seek variances in appropriate cases involving the career offender guideline, citing the increasing rate of below-guideline sentences in these cases. The Department would therefore welcome the opportunity to work with the Commission to analyze severity levels associated with this guideline as part of our broader efforts to ensure that the guidelines are fair and consistent in their application. The Commission, however, has not sought input at this time regarding the severity of the career offender guideline. Rather, its important questions focus on matters that go to consistency of application of the guidelines. And no doctrine produces greater inconsistency at the cost of a tremendous investment of resources than the categorical approach. I last had the privilege of testifying before this Commission on this topic on behalf of the Department in November 2015. At that time, I spent a significant portion of my statement explaining the incongruity and harm of this approach. I do not believe that that is any longer necessary. Indeed, judicial criticism of the doctrine has become a crescendo. As digested in our letter, numerous judges have forcefully and often colorfully condemned this approach, in which courts and litigants are compelled to spend enormous resources focusing not on the offender's actual conduct, but on whether some other hypothetical person could violate the same statute but do it in a less violent way, with the frequent result that some defendants who committed even the most horrific acts, murder, sexual assault, and vicious attacks, are incredibly found not to have committed, quote, crimes of violence. Notably, in the application of the sentencing guidelines, this approach was never required by this Commission. It was imported by the courts from the Supreme Court's interpretation of the Armed Career Criminal Act, which was motivated by concerns that do not involve the current guidelines, most notably the restriction on judicial fact-finding that increases a maximum sentence. This is most evident from application of the so-called Shepard rule, very severely restricting the examination of criminal records to documents that so frequently do not reveal the full background of the case at issue. All of this prevents courts from doing what they do expertly and what the Sentencing Reform Act demands, considering each offender before the court based on her actual conduct and actual history in an effort to impose consistent sentences on similar offenders. Accordingly, the Department has consistently advocated that the definitions in the Career Offender Guideline rest on actual conduct. We support the Commission's sensible proposals to fix anomalies in recent case law by making clear that Hobbs Act robbery is a crime of violence, that the guideline reaches inchoate offenses, and as discussed yesterday, clarifying the definition of controlled substance offenses. We also support the suggestion that the Elements Clause should be expanded to reach conduct that matches either the elements or means of the statute of conviction. These suggestions would allow courts to consider readily available and reliable information and reach consistent determinations regarding the treatment of violent and controlled substance offenses. We appreciate the Commission's efforts to address the problem through a new approach, which would call for comparison of the offense of conviction to specific guidelines. Although that may be an efficient approach with respect to federal crimes, we have serious concerns that it would create, in effect, a new categorical approach for state offenses as courts struggle to match hundreds and even thousands of state offenses with particular guidelines. We therefore welcome the opportunity to work with the Commission to improve on these proposals and hopefully rid the system of this problem. Again, I am privileged for the opportunity to testify, and I welcome your questions.
Thank you, Mr. Zalzman. He welcomes our questions, ladies and gentlemen. Have at it.
I know Mr. Zausmer, so I'll start. It's good to see you, Mr. Zausmer.
Good to see you, Judge.
Mr. Zausmer, you open your letter suggesting that we may consider postponing this decision and suggest that we hold hearings for further consideration. If we do that, who do you think we should invite? What sorts of issues should we be exploring with these folks? And I'd really like to know what your suggestion is the best fix with respect to the categorical approach.
The number of questions there. Thank you, Judge. First of all, there are proposals that are made that we support that we think can be done right now. The Hobbs Act robbery issue. That is just an anomaly. This commission in 2016 amended the definition of extortion to say physical injury. The goal was to exclude harm to reputation and things like that. Had very unintended consequences, which it essentially eliminated Hobbs Act robbery as a crime of violence, hard as that is to believe, in 5 circuits. It jeopardizes the application to any extortion statute anywhere. That's an easy fix in our view. Same with inchoate offenses. That was a completely unintentional result of, I think, of the Kaiser decision. No one has ever seriously disputed this commission from day one has included inchoate offenses, attempt, conspiracy, etc. Now in some circuits they're not included because of this odd administrative law rule about where in the guideline the thing can fall. So those are easy fixes that would be quite helpful. And the last of those, I think, is the controlled substance definition, which I know you exhaustively talked about yesterday at the hearing with my colleague, Ms. Mitchell, where we have this very strange application of the categorical approach such that if a state hasn't removed a radiopharmaceutical substance used to diagnose Parkinson's disease, that no cocaine offense qualifies. That should be fixed by making clear that it rests on a state definition. We support those proposals. We believe that should be done now. Our bigger goal, and what we've consistently advocated, including when I was here in 2015, is that, especially for crimes of violence, that courts be permitted to focus on actual conduct. That wasn't published by the Commission in this proposal. What is the listed guideline approach that we have concerns about. And that's where we do suggest that if the Commission is looking at that it hear from a broader range of people than I think it's heard from so far. This Commission, I don't think you need my advice, it's historically so good at reaching out to the courts, to the bar, to prosecutors, to victims, to other advocates. And those are the people I think who would have much to say if this actual conduct proposal were again put forward.
Thanks so much for having us. With being with us, Mr. Zasmer. One of the arguments that's often used against an actual conduct approach is the prospect of mini trials being hugely resource intensive for courts and it being difficult to get old evidence about priors for those mini trials. Do you have any thoughts on this issue?
Yeah, I do. As you can tell, I have excuse me, a number of thoughts about these things. I don't believe that that's a legitimate concern. I think in most cases, it's very straightforward to show from reliable documents what the evidence was. This is what courts do all the time. And in every other aspect of the sentencing guidelines, courts have always been expected to look to any reliable information to find facts by a preponderance of the evidence. This has worked efficiently for 35 years. And so there's no reason to think that that wouldn't happen with regard to prior offenses. When we have these concerns, when these matters come up that produce such anomalous results, especially with regard to violent felonies, we have no doubt as to what the facts are. We have reliable police documents, we have reliable interview reports, and perhaps the government needs to call a witness and let the judge hear from a victim or hear from a witness. That's not burdensome, and it's not inappropriate in the pursuit of justice. I just read Judge Cabrena's opinion, I think from yesterday, regarding where he had to spend 30 pages analyzing whether an assault was a crime of violence. That defendant killed a man. That doesn't take long to prove. And I don't think that that would be a problem across the board. So, and again, I think it's a worthwhile endeavor. And when you compare it to what's happening now in terms of the investment of resources, I think we would be in far better position. If I could just use one more example, the Third Circuit, where I reside, recently decided this case called Brasby, and I know that I know Judge Restrepo is familiar with it. Would have read this opinion and reviewed it when it was circulated to the court. Brasby is a decision, again, involving whether a New Jersey aggravated assault statute. Brasby involved whether a New Jersey aggravated assault statute qualifies as a crime of violence. Again, a matter in which the defendant shot a man 4 times in the back. But to resolve this under the categorical approach, the Third Circuit panel, the opinion written by Judge Julio Fuentes, had to spend an extraordinary amount of time. The court was required to find the generic definition of aggravated assault. That's what's required by the guideline. And had to review the aggravated assault statute of all 50 states and the District of Columbia and treatises to reach the conclusion that, yes, this man committed a crime of violence. That's an expenditure of resources that just makes no sense.
Understand Commissioner Gleason has a question now. Commissioner Gleason, if you can hear me, please ask your question.
I can. Thank you, Judge Reeves. Thank you, Mr. Zasmer, for your testimony and for giving us your time. Now, my question steps back a bit from the criminal history approach and the categorical approach, and asks your thoughts about the degree to which, if there are any guardrails on the degree to which the Commission might stray from congressional or Supreme Court prescriptions. And what I mean by that is obviously this categorical approach, which was fashioned by the Supreme Court, has kind of the implicit blessing of a Congress that has essentially ignored importunings to fix it for decades. And there's other contexts as well that we've discussed this, whether we stray from, whether the Commission should feel free to stray in connection with safety valve from either the statute or judicial interpretations of the statute. And I'm just curious as to what your thoughts are in terms of how the Commission should think about charting a separate course, and the one charted by Congress or the one charted by Supreme Court precedents, and the degree to which sound sentencing policy ought to be something the Commission should feel free to promulgate, even if it's different than the rubric, the policy fashioned by Congress or the policy that is the result of Supreme Court precedent. kind of curious as to your thoughts as to the freedom of the commission to do what it thinks is fair. Any number of contexts in which we might change policy depending on what the guardrails, if any, are.
Yes, Judge. I think this commission has considerable leeway, which has always exercised to develop sentencing policy. The guardrails set by statute are there and must be abided. The career offender guideline is an excellent example that is mandated by Congress. But once you get into the details, that's what this commission is about. The entire sentencing guideline manual consists of specific details that do not flow directly from any congressional directive. Congress, for example, set the statutory penalties in very broad ranges for drug offenses, and then this commission fine-tuned it down to very specific quantities. There are millions of examples, maybe not millions, but certainly hundreds of examples in the sentencing guidelines of this commission exercising its authority to develop policy, subject, of course, every year to the rejection by Congress if it disagrees with particular guidelines that this commission has adopted. So the categorical approach then is a very good example. That is not dictated by Congress. It hasn't been approved by Congress. Perhaps, as Judge Gleason, as you suggest, Congress by its silence has approved the application of the categorical approach with regard to the Armed Career Criminal Act, because that is a statutory interpretation that the Supreme Court made that Congress has never seen fit to correct. But there's never been any suggestion by the Supreme Court, by Congress, by anyone else that the categorical approach is required in the application of the guidelines. To the contrary, what this commission said in its very first introductory statement that has always been there and that has never been disapproved by Congress, this commission focuses on actual conduct. The goal of the guidelines is to impose similar sentences on similar offenders, meaning looking to their actual conduct and history. And I think it's fully consistent with that principle not to accept the categorical approach with regard to the application of the guidelines. And that's been the position of this department for at least the last 10 years.
Thank you, Judge Reeves.
All right. Yes.
I have another question. Would you mind responding to the arguments of the public defender to the extent that I know they haven't testified yet, but to the extent you're aware of them, regarding robbery and inchoate offenses? So with respect to robbery, the argument, or Hobbs Act robbery, the argument is that Hobbs Act robbery really should not be treated as a crime of violence because it could involve non-imminent threats of force and force against property as opposed to persons. And with respect to inchoate offenses, the argument is that inchoate offenses are inherently less severe than the principal offense.
Right. I'm happy to. I have such great respect for the defenders, and I've worked with them for so many years. But I really appreciated Mr. Caruso's testimony yesterday that I watched before this commission when he said they take their opportunities when they come up. And I think that with respect to the objection to the categorical approach, that's what this is. I fully understand and respect that they wish to see fewer long sentences imposed on their clients, and if an opportunity arises, they're going to take it. But I don't think that that's a legitimate basis, especially with regard to what you're talking about, Commissioner Murray, those two examples of robbery and inchoate offenses. Hobbs Act robbery is the traditional violent crime that Congress has always targeted. In fact, if you go to the statute, which again I don't think should govern here, but if you look at the Armed Career Criminal Act, the first version of the Armed Career Criminal Act did not have an elements clause. It didn't have what we're now familiar with. It had robbery. That was it. Robbery was the archetypal violent crime that Congress has always focused on. And if you have these extreme examples, which I don't think I've ever seen in practice in over 30 years of somebody threatening property in the future or whatever those examples are, then certainly a court could address that through a variance or some other means. But Hobbs Act robbery, what we deal with day in and day out, and it's always been a particular problem in my district, are violent crimes. These are forcing people to turn over their property at the point of a gun. I mean, that's what this crime is. This commission, and I think what we have here from the defense side is an opportunity. This commission never said that Hobbs Act robbery is not a crime of violence. Hobbs Act robbery was always treated by the courts as a crime of violence under the guidelines because it fell within the rubric of both robbery and extortion of the generic definitions. The commission in 2016 was concerned that extortion might reach threats to reputation and not threats of harm, and so made this one tweak in the application note that said extortion involves physical injury. The extremely unintended consequence of that was to eliminate Hobbs Act robbery and probably extortion as a crime of violence everywhere, and it's not what the commission intended. The fix to that is very straightforward. It's either to make clear that physical injury includes injury to property, which has always been true. You know, you look at extortion and you go back to why that has always been targeted by Congress. It goes back nearly 100 years. It's all concern about organized crime. It's the classic, you know, that's a very nice store you have. It'd be terrible if anything happened to it. That's a violent crime to threaten extortion like that. So make clear that physical injury includes injury to property. Or another solution, which I think would be totally appropriate, is to match the elements clause that exists now to Section 924C, which refers to person or property. And that's why, oddly, Hobbs Act robbery remains a 924C crime of violence, and it's not a guideline crime of violence in many places at the moment. But robbery is a violent crime. Inchoate offenses, again, a product of unintended consequences. This commission, I don't believe it was the first version of the guidelines, but it was the second, included inchoate offenses of conspiracy, attempt, aiding and abetting. There was never any argument that I know of before the commission over the decades that that was inappropriate. Instead, an opportunity arose. The Supreme Court decided the Kaiser case in 2019. It said that an agency can't interpret an otherwise unambiguous regulation. Clever people said, let's apply that to the guidelines, even though we know that the guideline manual was always written as one book with the text and the application notes. But now we have courts saying, nope, that's an agency interpretation, and thus application notes like that addressing inchoate offenses go by the wayside. That has nothing to do with whether these are appropriate offenses to look at as career offender predicates, and we hope that gets corrected.
Could you address the argument on the merits, though? I mean, I know the provenance, I know that it's somewhat accidental that inchoate offenses are no longer included, but now the PD is, you know, very justly, or, you know, at least it's fine to make the attempt, saying, yeah, but these aren't as serious. They shouldn't be included as crimes of violence. Why are they as serious to you as principal offenses?
Sure, well, they are serious. I mean, aiding and abetting always involves an actual completed offense. Conspiracy to commit an offense, the law going back centuries recognizes that as a dangerous crime. When multiple people get together and agree to commit a crime, I don't want to take everybody back to law school, but when multiple people get together and agree to commit a crime, the odds are that crime is more likely to happen, and that's a serious matter. And attempts, what we see are very violent. I'll just give you an example of what we're dealing with. The Supreme Court decided the Taylor decision, as you know, last year, holding that attempted Hobbs Act robbery is not a crime of violence. And as a result, in my district alone, I'm handling about 70 cases in which we're going back and resentencing people whose 924C offenses no longer qualify. And I can tell you almost every single one involves horrific conduct, where the robbery didn't succeed because the person was caught, the person was tackled, the person was shot, but not before accosting someone at point of a gun, even shooting people, very violent matters in which we now have to go back into court and say, Judge, look, this is violent. The example that the Supreme Court gave of the person making plans, gathering equipment, being caught on the way into the store, that doesn't happen. It's not our real life experience of what attempt offenses are. They're violent crimes.
I just have a follow-up. Thank you, Mr. Zosmer, for your testimony today. We appreciate your time and being with us today. On the culpability issue with the inchoate offenses, the examples you gave were for violent offenses. What about those offenses as to the drug offenses, keeping in mind the Commission's 2016 report too, and kind of concerns that have been raised by the Commission about the drug predicates for the career offender?
That's a very good question. I would likewise say that with regard to conspiracy and attempt, that those involve actual conduct which involves the type of conduct that is serious and that we're targeting. I also can't think of examples of where, for example, there was a conspiracy charge without actual drug trafficking. Often, as you know, the conspiracy charge is used to embrace a good deal of activity in order to make the charge more efficient. And similarly with regard to attempt, it's an unusual case in which there hasn't been actual trafficking. And if there is some anomalous case, again, I think that can be addressed through a variance. I do think, though, that what you're saying, I think, raises an important point about the problem with the categorical approach, which is that the problem historically, meaning over the last 30 years or so, has not been so much on the controlled substance side. It's really a violent crime issue. And the reason I say that is that it's only in recent years where we had these anomalous problems that I've talked about. The inchoate offense issue arising because of the Kaiser decision, and this controlled substance definition problem, which we've only seen in the case law in the last couple years. Before that, we really had no difficulty in applying the career offender guideline to controlled substance offenses. Now, I am well aware of the concern that this commission has raised and others have raised regarding the severity of the guideline as applied to controlled substance offenses. And as I said in my statement, I do believe that's an important issue for the commission to address, and I hope the department has the opportunity to engage with the commission on that. The problem with the categorical approach, though, has been on the crime of violence side. That's where we get judges like Judge Fuentes being compelled to spend a year researching aggravated assault. That's where we get results such as people who've committed rape and robbery and murder being found not to commit violent crimes. The whole resource problem, the whole inconsistency problem was always on the crime of violence side, and will still be there even when this commission hopefully fixes those anomalies regarding the controlled substance definition and regarding inchoate offenses.
Mr. Sosmer, we hear a lot about the burdens of applying the categorical approach sort of at the front end. I think that's very well known and widely established. But you referred just now to a large number of resentencings you've been handling in the wake of Taylor. And I'm just wondering if you could talk a little bit about the burdens, to the extent there have been, based on the categorical approach being the current state of law.
Yes, absolutely. I mean, the burden exists at all levels of the judicial system. The district judges, of course, have to deal with this problem on a daily basis, and then appellate judges as well in doing the types of exercises I've talked about. And often there are reversals on this basis, or even concessions. That's where people like me come in when you're the appellate lawyer and you take a look. And I recently had a case involving a district judge in which he strayed just a little off base, and we had to say it. He looked at the actual crime that the person committed and said, "Are you serious? You know, you're telling me this is not a violent crime?" And he moved on to the other issues in the case, and we had to agree to a remand. And yes, it's a significant burden on judges and on prosecutors in having to deal with these issues on I know I'm repeating myself, on what should be the most straightforward questions. Did the person commit a violent crime in the past? I should also mention that, we've talked a lot about career offenders. That's not the only place, as you all well know, that these definitions apply. They also prominently apply, for example, in the firearm guideline. And in fact, the firearm guideline is applied by the courts far more often than the career offender guideline. And our most serious problem, as this commission's data has shown, is with violent offenders who then rearm themselves. They are the most dangerous recidivists. And so we have this crime of violence definition being applied to them. And that creates difficulties in coming up with consistent sentences. And all of this, again, is not just a burden problem, and it's not just an anomaly problem. It's also an inconsistency problem. It is a problem if somebody who commits a robbery in my home state of Pennsylvania is looking at a completely different guideline range than someone who commits the exact same forceful robbery 5 miles away in Camden, New Jersey. But that's the situation that we're dealing with.
To follow up on Commissioner Wong's question, Mrs. Osman, has DOJ, you said you had like 70 cases that you know of in your situation that you have to, look back at. Is DOJ keeping any stats? Has DOJ asked all U.S. Attorney's Office, for example, for data or information on the number of cases they might have in each of the circuits, or in your circuit, or in any of the circuits, or whatever?
We have not been asked for that yet. We could ask if, at the commission's suggestion. The Taylor problem is focused, and the Taylor problem is recent in needing to go back and look at attempted Hobbs Act robbery predicates for 924C offenses. The career offender problem spills, to many different areas, and no, we have not been asked for data on that. I can just tell you from experience and from my dealings with the department and with prosecutors around the country, this is a significant regular burden on prosecutors and courts to have to deal with these issues.
Thank you. Yes, Commissioner Murray.
Are there specific, I don't know how at what granular level you have dug in, but are there specific state statutes, the application of which gives you concern in the context of the listed guidelines approach? The department's letter read a little bit to me as if it wasn't so much a concern with the listed guidelines approach per se as just the thought of like starting over. So obviously there's a lot of water under the bridge on the categorical approach, and if you were to modify it by undoing de camp and imposing Mathis, then maybe you could, use some of that work already, whereas the listed guidelines approach really means like you have to start fresh with all of the state statutes and figuring out how they apply. And obviously one of the things we're trying to get a handle on is how complicated would this be? How often would it be a problem? And we've heard our Tribal Issues Advisory Group has told us in the context of the Major Crimes Act that they've done this analysis quite a bit, or they have seen it done quite a bit in the tribal context, and it hasn't been a huge problem. Our probation officers seem willing to tackle it, but the department seems very cherry, and I wonder if there are like particular scenarios that are giving you pause. Like where does the department's hesitancy about the practicalities come from?
Sure. Well, on the federal side, we don't have a concern. On the federal side, it's very straightforward, and it's a very clever proposal. The alternative approach also on the federal side would be simply to list statutes, which we don't think would be a difficult endeavor. It's on the state side that it's sort of we're concerned about what we don't know. What we do know is that defense lawyers are really smart, really capable people, and they will find the discrepancies between state statutes and particular federal guidelines. We focused on assault as an example. There are myriad assault provisions, and you can see this in all the case law regarding the categorical approach, very often not called assault, but expressed in terms of domestic violence and other things like that. And yet we'd be dealing with one specific guideline to fit into in the current listed guidelines regarding aggravated assault. And it would be an endeavor, and it would be difficult. And I guess I'm just speaking from my experience of being involved in this litigation for so many years. I just feel confident that there would be not just a great deal of litigation, but inevitably inconsistent results and disagreements between courts. And it would take us back, even with all the difficulties we've had, it would take us back on some matters that were already settled. That's why if this commission does go with a listed guideline approach, we do suggest some ways to ameliorate that. One is leave the elements clause and expand the elements clause to address means, as is in the proposal. That will at least keep us with the precedent that we already have regarding many, many statutes, and that would be very helpful. Do not have a limit to Shepard documents. That is just an artificial limitation that prevents us from looking at what was the conduct that led to the offense that the listed guidelines approach proposals. And we also have concerns, as we wrote, about the recklessness exclusion, and we had suggestions about that. So those things would definitely help. But again, I just know from experience that I could be sitting here a year from now and talking to you about this sea of litigation that will result.
Doesn't leaving the elements clause leave us in the worst of both worlds? Because it may be settled that Kansas burglary is a crime of violence in the 10th Circuit, but you could have a defendant who lives in Virginia who has a prior Kansas burglary, and it might be not settled in the 4th Circuit. So aren't courts still then going to have to do the categorical approach?
Well, no. What I'm saying is that in the listed guidelines approach, it says look at the conduct that led to the offense, but limit yourself to the Shepard documents, which very often doesn't tell you the conduct. What would be in the improvement on that is, yes, look to the conduct, but look to the elements or means of the offense. In a court that has already decided that the elements of the offense are sufficient by themselves, you're done if you keep the elements offense. In those courts that might not have concluded that, then we're in a better place. Now, according to the proposal, we can look to the conduct, and we can look at the means, and we can now have a different result in those places.
But won't, maybe I'm not understanding, but won't courts and prosecutors and defense attorneys basically still have to be in the position of still having to do the categorical approach, because there will now be two, in places where it's not settled, there'll now be two methods of proving that someone has done a crime of violence?
Right, but I don't think that's a laborious process. I think you know instantly from precedent whether it qualifies under the categorical approach under the Elements Clause. And if it doesn't, then you would now have this new permission that the Commission has proposed to look further than that. And I think that's definitely an improvement. Again, to recap, I mean, the ultimate improvement that we suggest is to make the more modest changes the Commission has suggested to include Hobbs Act robbery, inchoate offenses, state-controlled substance offenses, but then permit us to look at actual conduct, not artificially limited to Shepard documents, in showing what was the basis of the crime of conviction, to show that, yes, that person unfortunately shot a man 4 times in the back, he's a violent offender and should be treated as such.
One of the things that I think that the federal public defenders will be saying is that at least the categorical approach sort of cabins how we look at things and does not lead to unwarranted sentencing disparity. What, if anything, is the department's view on that? Because we do have to always be mindful of unwarranted sentencing disparity and all of that, and if you have any response to it.
I do, thank you, sir. Cabining what we look at is inappropriate. I remember one quote, I believe it was from the 11th Circuit. It began a decision some years ago talking about why a sexual assault statute was not a crime of violence. And it said, here we go again down the rabbit hole, to a place where we have to close our eyes to what we know as men and women, and focus only on the elements of a crime and how it may be committed by someone else. That's wrong. Yes, it cabins what we can look at, and it leads us to unjust and inconsistent results. And with regard to disparity, it's the categorical approach that produces disparity. It's the reason that just in my circuit, that a first-degree aggravated assault, one of the most serious crimes one can commit other than murder, a first-degree aggravated assault in New Jersey is a crime of violence. A first-degree aggravated assault in Pennsylvania is not. Why? Because there's a Third Circuit decision that we've consistently challenged regarding Pennsylvania first-degree aggravated assault, that there was one case in which a woman was convicted of that statute for starving her child to death. And the Court of Appeals said that that is not a use of force. That is an absence of use of force. And therefore, it doesn't categorically qualify, so that no one in Pennsylvania who commits first-degree aggravated assault has committed a crime of violence, even though those in every other state and jurisdiction in our circuit has. That's disparity. And I think that undermines confidence in the law. It's not appropriate, and it's something that we urge the Commission to fix.
Thank you. Oh, did you? No, did you have? No, please, if you hadn't.
Mr. Zonsmer, I know the department's made its support for an actual conduct approach known in the past, and there have been some concerns about the actual conduct approach. And I'm just wrestling a little bit with whether the department's position here is letting sort of the perfect, in your view, be the enemy of the good. And I'm wondering if, in the event that an actual conduct approach is not viable, what kind of relief to the enormous burdens you started out here talking about the current status quo are truly relieved by your sort of fallback position that just retain parts, the current definitions, parts B to D of the Commission's proposal?
Well, the advantage, Commissioner, is that, again, we've had to litigate so many of these issues. We'll continue to litigate them. Judge Cabranes and others will continue to write these opinions. But obviously there's been progress. And the modest suggestions that the Commission has made do resolve many of the disparities I've talked about. Hobbs Act robbery should be a crime of violence everywhere. So should inchoate offenses. State cocaine and heroin offenses should be controlled substance offenses. Get everybody to the same playing field on that, and I think we're in a much better position. We then have this very significant issue to talk about, especially with regard to controlled substance offenses, as to whether the penalties are too long, and that should be done. But at least we would have a much greater amount of consistency. We would have less litigation on these issues, on these very straightforward questions, and I think we would be in a better place.
With the department, I'm sorry,
No. We're over time, but we need this information. No, we need this information.
Would the department be happy if we went with your fallback approach, which, as I understand it, is undoing DeCamp and applying the Mathis approach broadly, but then we did not go with your approach of opening things beyond the Shepard documents, so we said, no, you're still limited to Shepard documents?
Yes, that would be very helpful, being able to look at means. The difficulty with the Shepard documents is that they often don't discuss the means. Mens rea is an example. If we have a recklessness exclusion, most often in a charging document, as you know, a prosecutor will just recite the terms of the statute. He did intentionally, knowingly, and recklessly do X, and thus the Shepard document has not answered anything. But there certainly will be cases in which they are helpful and do explain what the means of the crime were. And so, yes, that's progress. Any progress here is helpful. I think that's one of the points that, I hope I'm getting across.
Are there any documents, like discrete documents, you think could be added to the Shepard universe without opening things up completely that would be particularly helpful?
I think the Supreme Court has defined what judicial documents are. The next step, and what Shepard precludes, is looking at police reports and other investigatory documents. And that's where we could urge the Commission to look at its traditional rule, which is that courts should rely on reliable information. That's what 6A 1.3 says. And that's what where we think this should go. So no, I can't tell you a specific document label that would be added.
Thank you for your indulgence.
Okay, all right.
I'm sorry, I'll just extend us even further with just one
Sure.
last question kind of related to before that. If we were to postpone doing anything with the listed guideline approach to kind of get more evidence and hear more voices on that, would it also be useful for us to update the research and work that was done in connection with the 2016 career offender report? Is that something that would advance that conversation?
Yes, I definitely think it would. I mean, we know the basics. We know that 80% of cases involving controlled substance crimes result in a variance, and I think we've heard from the courts loud and clear as to the severity of the guideline. But additional data would certainly be helpful to specify it. And I do think what it would show is that the court's appropriate focus is on severe punishment for armed recidivist criminals, that will always remain appropriate, who are violent criminals. But yes, I think they would bolster that and would be worth looking at.
Thank you.
All right. Thank you for being patient with us, Mrs. Osmer.
Thank you very much for your time.
All right. This concludes his time with us. We'll get ready for our next panel. Second panel provides us with the perspective from the federal public defenders on this particular issue. To present that perspective, we have Javal Scott, who serves as a federal public defender for the Western District of Virginia. Ms. Scott has previously taught criminal procedure at Washington and Lee School of Law and served in the training division of the Defender Services Office. Ms. Scott has previously served as a public defender in Wisconsin and Indiana. She regularly teaches at local CJA panel trainings and programs sponsored by the Defender Services Office Training Division, as well as the National Criminal Defense College, National Association of Criminal Defense Lawyers, and its affiliates, among others. Ms. Scott, thank you for coming. We're ready to hear from you whenever you are.
Good morning, Chief Chairman Reeves and Commissioners. Career offender. This label evokes a certain image. A person who breaks the law with purpose and impunity. A professional criminal. But defenders who have represented thousands who receive this label know this often doesn't match our reality. Our clients who are designated as career offenders include minimally involved people who were pulled into street-level sales at a young age. They include people grappling with substance misuse, who have sold drugs to sustain their own habit. Many are Black and Native youth who were waived into adult criminal court way before they could vote. And many have never spent more than days behind bars, and they now stare down the barrel of decades in prison. And many have been subjected to enhanced penalties triggered by the racist, unscientific crack cocaine disparities. Because it only takes 2 prior convictions to qualify for the career offender designation, criminal history categories are often doubled, placing someone who falls into criminal history category 3 into criminal history category 6. This drastic shift causes judges to rely on the guideline to sentence clients who have served little time in jail for prior offenses to 30 years or more. And this is done even though the guideline lacks an empirical basis. If the Commission expands the reach of the career offender guideline, which each part of the proposed amendment would do, many more people would face the possibility of a guideline-based draconian sentence like the ones we've lamented for decades. This is untenable. My written submission dives into the details, but today I will discuss 3 primary reasons the Commission should not adopt any part of the proposed amendment. First, the career offender guideline is overly punitive, lacks empirical basis, and drives significant racial disparities. During the height of the failed war on drugs, the Commission crafted a guideline that nearly 80% of judges no longer follow because it fails to reflect sentences that are no greater than necessary to serve the purposes of sentencing. Individuals identified as career offenders are a small percentage of those sentenced in federal court. But because lengthy sentences are a driver of mass incarceration, those individuals make up a disproportionate percentage of the federal prison population. By expanding both the methods of identifying career offender predicates and the predicate categories themselves, the Commission's proposals will vastly increase the pool of impacted individuals. The Commission cannot ignore that these exceedingly severe sentences are imposed disproportionately on Black individuals who are designated career offender status at nearly 6 times their white counterparts. Because the career offender guidelines identifies categories of individuals subject to near maximum term sentences based solely on criminal history, it bakes in our nation's racially disparate law enforcement practices. Second, it is important to consider why the Commission has recommended the expansion of the guideline. The impetus behind some of these proposals seem to be a desire to simplify federal sentencing. But if that is the objective, these proposals won't work. The proposals will spawn increased litigation. To be clear, simplification should not justify the wrongful and broader imposition of harsh penalties. But even if it were a valid justification, the Commission's proposal will create more, not less work. As our written testimony explains, the Commission's proposal will increase litigation. With the Commission's proposal for the alternative categorical approach, courts will be required to make an accusation-based finding in each case, undermining the simplification and uniformity that the Commission seeks, and the materials judges use may be unreliable to identify conduct. The proposed amendment would also sweep in inchoate convictions, which are quite literally not a crime of violence. And the charge will generate new and unique issues for the courts to decide. Finally, the Commission's data supports the defender's assertion that the career offender guideline should be contracted rather than expanded. Commission data over several decades have indicated that the career offender guideline calls for sentences that are too high in most of the cases it captures. Importantly, the data suggests that recidivism rates of individuals placed in criminal history category 6 because of the career offender designation are actually more in line with the criminal history category that they would fall in if you went with the original calculation. And there's no empirical data that supports this. And the Commission if I could just briefly conclude, has previously acknowledged the longstanding policy concerns with the career offender guideline and recognized the need to narrow the guidelines. My testimony today is driven by the lives of the people my colleagues and I stand beside in court every day. I have seen too many of their lives destroyed by an unjust and racially disparate punishment regime. The Commission's proposal would maintain and exacerbate this broken, non-empirically status quo. The result would be more needless incarceration of Black men, more broken families left behind, more promise lost. I urge the Commission to not expand this broken guidelines reach.
Thank you, Ms. Scott. Turn to my fellow commissioners.
Ms. Scott, let's assume we agree with all your criticisms of the current state of the law. You heard Mr. Zausmer testify. I got two questions for you. Do you have any common ground with, not the department's position? In other words, do you agree with any of the suggestions Mr. Zausmer made in order to move the needle in the right direction? And what do you propose in lieu of the current state of the law? Should we look at actual conduct?
Thank you, Commissioner. I will attempt to be brief in my comment. I agree with the DOJ and their acknowledgement that we need to address the severity of the guideline. I think it's a bit out of step to expand the reach of the career offender guideline when we know that we need to address the severity of the guideline. If we understand, and I think we all do because your data says it, that 80% of individuals that fall into this category aren't being sentenced pursuant to the guideline, it suggests that we need a broad critical look, a thoughtful look at the guideline, one that allows us to determine when the guideline should apply, who it should apply to, and in what manner. And until that's done, it doesn't seem as though we should expand the reach of the guideline. If we expand the reach of the guideline with the current severity in place, more judges are going to ignore the guideline. So it doesn't fix the issue. Judges aren't ignoring the career offender guideline because the categorical approach is complicated. They're ignoring the guideline because they don't agree with the guideline range that the Sentencing Commission has set forth. And so I think we need to start there. So I do agree with the Department of Justice, and I was elated to hear them say that they believe that this is something that should be addressed. And like the Department of Justice, the defenders would happily work with the Commission to figure out ways that we can come up with meaningful, thoughtful approaches to the career offender guideline. To answer your second question, what do I believe that you should look at, what documents I think should be looked at? It was curious to me that the government believes that you should be able to look at police reports and things of that nature. I've actually been a prosecutor before, and so I recall that when I was a prosecutor, I would go in front of the court and I would give a factual basis, or we would have these accusations that were before the court. And I remember on occasion defense attorneys would object to the factual basis that was laid down. And my response was always, objections noted, the elements have still been met, and the court moves on. I've also, on the defense side, been in front of a court and objected to the factual basis and things of that nature that were put before the court, and had a judge tell me that if my client didn't accept the factual basis as is, that client would just simply need to proceed to trial. So we have accepted on many occasions factual bases that did not encompass behavior that the accused, that the person who ultimately pled guilty agreed to. And I think that that's important when we say that these are reliable documents. I think it's even more far-fetched to say that police reports are reliable documents. It's as if the government fails to recognize that police reports often contain false information. Need we look beyond Tyree Nichols that happened just in January, where we know the police reports contain false information, and but for rotated cameras and national news coverage, that would have been the narrative? I have personally handled cases where evidence has been suppressed and judges have found law enforcement testimony to be incredible, I don't think that we need to expand this. I think that we need to come up with a data-based approach to figure out who deserves the punishment, what the punishment should be, and what it should look like, so judges will pay it attention.
What data should we be looking for?
So I think that this is a very nuanced issue. I mean, it appears that the Department of Justice agrees with us that, the overreach of drugs and the impact of prior drug convictions and what it means in the context of career offender, really, it's overstated. So I think that we've got some agreement there. We too agree that drug convictions are not a reliable marker in terms of determining the career offender guideline. I think that we need to call in a group of stakeholders. I think it's nice to talk to prosecutors and defense attorneys who have kind of this vested interest in our side. I appreciated that the government said that we are taking advantage of opportunity, but I choose to disagree with that. We're not taking advantage of opportunity. What we're taking advantage of is the ear that you are willing to lend us, and the ear that's willing to finally understand the clients that we represent and the stories that underlie the paths that lead them into the federal legal system. So I think that we need to look at sociological, psychological data. I think we have to look at community-based data. I think we have to, take a bigger look at the impact of sentences. So many of the studies that they do on the impact on the impact of incarceration, they look at it in larger swaths. I think they need to be broken down more critically. We do know, as my colleague Leslie Scott and I believe also Michael Caruso testified yesterday, that the longer individuals are in prison, the purported deterrent effect turns into criminogenic factors. And so I think that we need to pull the layers back. This is an opportunity. The commission is vested with the power to engage in those studies, and I'd happily sit and or provide written follow-up into various areas that we believe the commission could look at to really make the guideline in this instance meaningful and powerful and something that judges would actually pay attention to.
Commissioner Boone and then Vice Chair Murray.
Good morning, and thank you for your testimony. Thank you. I'm very familiar with the 2016 Commission report on career offenders, and frankly, cite it frequently when varying with offenders who qualify for the career offender guideline application. When those offenders qualify for the drugs only, via the path of a drugs only predicate offense. That report specifically was aimed, I think the conclusion was the recidivism rates for those offenders do not match, are lower than the recidivism rates for those who qualify based on crimes of violence. And so the commission's suggestion was that Congress should amend the statute, and ultimately that the career offender enhancement should not automatically apply for those who qualify based on the drugs only. And, that was based on a data-driven approach. And I, as I said, I'm very familiar with the report and frankly cite it often for those who qualify for the drugs only, by the drugs only path. My question is, though, how then does the commission comply with Congress's directive, in particular to those who qualify based on crimes of violence? And how does it jive if we're not looking at actual conduct with 3661 and the courts, what the courts do every day, which is look at the total conduct of each and every crime and each and every offender, and try then to impose a sentence that is sufficient but not greater than necessary. And so I guess, the point of my question is, how then do we comply with Congress's directive for those, especially qualifying under the crimes of violence path to the career offender status?
Thank you, Commissioner. I believe that this is why empirical data is helpful. I think that the commission really needs to use a data-based approach to figure out what those sentences should look like, even in the context of those who have committed offenses that you've described as violent. I think it is important to note that when we say we want to look into the actual conduct, there's oftentimes, and I can't say this enough, there's oftentimes disagreement as to what the conduct was for a predicate offense. It's not enough to say that the charging document said this and the person, pled to X. And so that in and of itself is that. It's not enough to say that a police report, as my colleague said, says someone shot a person 4 times. The police report is not one sworn testimony, and even though they're technically crafted under the penalty of perjury, I can find you multiple examples, both public and not public, where they've had false information. Now, what I haven't seen is the Department of Justice taking an approach where they stop that by prosecuting those same officers for perjury, right? And so when we say that we can rely upon this back information, essentially what we're doing is opening up every single sentencing hearing that has a career offender predicate where there's some sort of disagreement into a mini trial. And I don't think that that's what is intended, right? And even in terms of factual basis, I think that there's some assumptions in factual basis. And I gave an example prior where my client was prohibited by the court from objecting to a factual basis, or he could go to trial and get a more harsh sentence. But there are other instances. It doesn't account for whether or not the person had, competent counsel. It doesn't account for all of the things that that regularly represent individuals in the field know to be true. People feeling compelled. Remember, the government has the power in any and all plea negotiations. And many times our clients are sitting there with the foot of the government on their neck while they take the factual basis that they're required to take in order to get the deal that's there. And many times that deal is the best thing for them, and so they do it. It doesn't make every fact correct.
Understood. I think those are all very good points. But what's your response to the department's testimony previously, where there are very clear, often admitted, crimes of violence that have been committed, and the current categorical approach simply does not address those instances of clear violent crime? And I'm trying to figure out, how do we reconcile, right, when we know either because it's admitted or someone is dead or has been shot? How do we reconcile that and address Congress's directive, which specifically requires that the commission set those penalties at or near the statutory max?
So I think there's 2 things. Congress's directive says that you set the sentences at or near the statutory max for some individuals. It should be a limited number of individuals is the way that I read the statute, but I suppose it could be read differently. But also the categorical approach doesn't, it provides a level of certainty that, just yesterday, Judge Loyer issued a concurring opinion out of the Second Circuit in an opinion called Morris, and he praised the categorical approach. And I think the reason why he praised it is 2 reasons, just kind of distilling them down. It serves an important practical purpose, but also it's more protective of clients at sentencing. And the reality is, if a judge is looking at an individual and attempting to determine, one, whether there's a career offender, they disagree, right? They disagree. They say, you know what? I don't like that the law says this is not a crime of violence. They can vary upward. Right? That opportunity is always available to a judge. So I don't think that we need to create a more expanded category of people that judges will consider to fall into the career offender guideline when judges already have an option to address it. But also I would like to address what my colleague said about having never seen any kind of conspiracy or any kind of I've never seen, I think he said something to the effect that he'd never seen a conspiracy that wasn't, completed. It didn't have some sort of act. I guess he's practiced in jurisdictions different than mine. I've practiced in 3. I've trained attorneys that practice in every single jurisdiction in this country. I've actually physically trained in more than 40 states. And I can tell you that my experience is different. In many instances, that is the case. So I think that to address your concern, Commissioner, if you are looking at an individual where the categorical approach suggests that it's not a crime of violence and you do not believe that the resulting guideline is harsh enough, every judge in the country does have the ability to vary up. I'm not suggesting that they do, but it is an option that's available for every judge.
Murray.
Thanks so much for being with us, Ms. Scott. I very much take to heart your comments and concerns about the severity of the career offender guideline regime. I guess one thing I'm wondering is if we can imagine a world where those penalties were set at levels that you thought were just, so you thought they were calibrated correctly. Is there an alternative to the categorical approach that you would advocate for or be comfortable with, or would you still kind of be most comfortable with the approach we have, which does create these anomalous results where cocaine is not a controlled substance and homicide robbery is not a crime of violence? And
Thank you for the question. You'll have to excuse, this is not question dodging. I just so happened to, in college I studied biology and chemistry, and so one of the things that we learned in science is that data was important. And so I do keep coming back to, it would be great to have some information before making that determination. I do believe that the defenders can come to a consensus, but we believe that it should be empirically based. And so we would love to work with the commission to figure out how we can come up with an empirically based change to the guideline to make it mean what it's supposed to mean. I think that if you have 80% of individuals not being sentenced to a guideline, it says that it needs to be retooled in its entirety. And I think that that's really the starting point for us.
You think in that case the defenders would be open to considering an alternate regime? I mean, because it does strike me that from a defense attorney perspective, the categorical approach is always going to let some reduce sentences, let some people off, right? I mean, it's a useful defense tactic, but are you bothered by the anomalies such that, if there weren't a severity issue, the defenders would be willing to look at other approaches?
I do find the language reduced penalty let some people off. Our clients still go to prison. They still are taken away from their families.
Sure.
And so, again, I'm less concerned with anomalies than I am with justice and fairness and a guideline that is racially disparate and bakes in everything we know about our nation's history and in the legal system. And I think that it's more important at this juncture, especially with where we are in terms of racial reckoning in every area of our lives, for the commission to engage in a critical, thoughtful process that does not continue to further perpetuate those racial inequities.
Commissioner Wroblewski.
Thank you so much, and thank you, Ms. Scott, for being here, for your testimony, and for your service to their country. I can't let this moment pass without noting the agreement between the Justice Department and the defenders on all kinds of things. I just jotted a few of them down. We agree with you that the new listed guideline approach will lead to more litigation, and that's your ethical responsibility. We can call it different words, but I think that's likely to happen. We agree with you about the career offender penalties as they apply to drug offenders. And we've said that many times. We agree with you about the data from the judges and I think Mr. Zausmer mentioned this, about departing from the career offender guideline. We agree with you that the commission should be data-driven. One thing I really, really hope is that after the commission makes whatever decisions it makes on the proposed amendments, that the commission the Justice Department, the defenders, the Judicial Conference can walk arm in arm up to Congress and seek legislation to allow the commission to take the steps that you're talking about in terms of a data-driven approach to repeat controlled substance and violent offenders under the career guidelines. So I just want to note that I hope we can get there in 4 weeks, and then we can go to Congress together. But I do want to focus on one part that we may or may not agree with. I'm trying to sort of channel my inner Judge Restrepo about trying to find that common ground. The Commission's research and data have shown repeatedly that the most dangerous offenders prosecuted in the federal system are gun offenders who have prior crimes of violence. And the Commission, as you know, is considering changes to the firearms guideline. And it seems to me that those penalties, as I say, are data-driven and directly lead to public safety because of the very, very high recidivism rates associated with these gun offenders. Would it be something that the defenders could possibly consider supporting, which is to go into that particular guideline, and not every gun offender, but gun offenders who have prior crimes of violence, and consider reforming the way those crimes of violence are determined under that one guideline, so that those penalties, which I think are data-driven and can support public safety, can work as they were intended. In other words, that people who genuinely have prior crimes of violence and then who rearm themselves and commit new crimes, that those people can be incapacitated for the length of time to improve public safety. Is that one area where we might be able to find common ground?
Thank you for your question. I believe my colleague testified yesterday that though there is some data on 2K2.1 that the Commission has come up with over the years, I believe she mentioned about 10 additional data points that would be helpful in terms of further interpreting that guideline to ensure, fairness and application. So I'm not in a position to say that we agree that the data is complete as it underlies 2K2.1, and therefore then would be influential in the way that we address the career offender guideline. I appreciate your comment about marching to Congress arm in arm. It is, I seek opportunities for the parties to agree, always with an eye towards fairness, of course, for our clients. I don't know that I think that the Commission is not able, under its current mandate, to use a data-driven approach. And so I would note that when I ask for a data-driven approach, I believe it's within the realm of what the Commission is able to do now.
Good morning. Thank you for being here. We really appreciate your testimony and taking the time to be here with us. One question on the data-driven work that we have to do. The same question I asked Mr. Zosmer earlier is whether it would be helpful in that approach for us to be updating the work that was done in 2016, which to me doesn't seem like that long ago, but I realize now it was a long time ago, and whether that would be a useful step to take as we work on this complicated issue.
I think always updating data, you want new, fresh data, but I think also expanding the information that the Commission is looking at to ensure that we're getting the proper data for the guideline.
Thank you.
Yeah. Further questions of this witness? Ms. Scott, thank you so much for your testimony. Appreciate you.
Thank you, Commissioners, for your time and attention.
Good morning. Our third group of panelists will provide us with perspectives on this issue from three of our advisory groups. First, we will hear from the Honorable Ralph Erickson, who serves as chair of the Sentencing Commission's Tribal Issues Advisory Group. Judge Erickson served as a district judge for the District of North Dakota before being elevated to the United States Court of Appeals for the Eighth Circuit. Judge Erickson has a long history of service on both the state and federal courts there in North Dakota, and he has served in various capacities on state and national ethics panels, including service as chair of the Judicial Conference's Committee on Code of Conduct. Second, we will hear from Susan Lynn, who serves as the Third Circuit representative on the Sentencing Commission's Practitioners Advisory Group. Ms. Lynn is a criminal defense and civil rights attorney in Philadelphia, Pennsylvania, that is. There's a Philadelphia, Mississippi. We get confused all the time. She teaches in the training division of the Defender Services Office at Temple University, Beasley School of Law, and the University of Pennsylvania Carey School of Law. Ms. Lynn currently serves as president of the Asian Pacific American Bar Association of Pennsylvania. Finally, we will hear from Joshua Luria, who serves as vice chair of the Sentencing Commission's Probation Officers Advisory Group. Mr. Luria serves as a supervisory U.S. probation officer in the Middle District of Florida. He has previously served as a U.S. probation officer in Brooklyn, New York as well. Judge Erickson, thank you. We're ready to hear from you whenever you are.
Chairman Reeves, members of the committee, I want to thank you for the opportunity to be here today. I also want to thank you for the opportunity to serve on TIAG. It is one of the great privileges of my career, and I think it's some of the most important work I've ever done. And if I might take just a minute to explain kind of the issues that we deal with, because I think there are people in this room who have no idea what kind of tribal issues we're talking about, and I'm certain that people online have no idea. And so basically we start with this proposition. There are 574 recognized federal Indian tribes in the United States. We use the terms Indian and Indian country because those are terms of art that are found in the United States Code. And so these 574 native nations are broadly diverse in ways you can't really imagine until you start working in Indian country. The bottom line is this: the largest tribe in the United States is the Cherokee tribe with over 730 members. The smallest tribe consists of 16 members. Of the Kahia, the St. Augustine Kahia tribe, it has 16 enrolled members. Obviously, the governmental structures, the courts that they operate, are different. TIAG itself is made up of people who are involved in Indian country legal issues where the federal courts and the tribal courts intersect. And what we try to do is address issues that are uniquely problematic within the communities that we serve, right? Now, if you think about that, our committee, our advisory group, is different than all the other advisory groups because it has a very broad membership. We have a tribal judge, we have a tribal prosecutor, we have a federal prosecutor, we have a federal defense lawyer, we have a probation officer, we have academics, and we have people who have experience across the board, been tribal judges, been tribal prosecutors, been federal public defenders. And so we have a broad practice spectrum. We have a policy that we have followed for the most part that unless we can come to a broad consensus within the TIAG, we don't take positions. And so, you know, we don't show up here very often on issues that you're considering because, frankly, we have deep division within our group, right? We have the people who appear mostly in tribal courts. They don't have much to say about what we're talking about oftentimes. We have the people who prosecute and the people who defense. They're sometimes at odds. When we show up, it's usually because we've identified an issue that either has a unique application in Indian country that you may not anticipate the sort of problems that we might find, or it's something that we've come to a broad consensus, and with a goal of trying to build consensus in sentencing policy, we think we might have something to add because of the just constituency of our TIAG. And so that's sort of the background information. On this particular issue, we are here with no position on any of the proposed amendments. Our purpose in appearing here today, and why I'm here today, is to just speak about the questions that have been raised about the administrability and the ability to manage or to make workable taking the most appropriate corresponding guideline approach, right? And I want to start with a little ancient history. Before the guidelines existed in Indian country, what happened is the United States courts have always had jurisdiction, well, since the 1890s, we've had jurisdiction over felonies committed in Indian country. Indian country consists of reservations, allotted lands, and aboriginal title lands. Aboriginal title lands are lands that a tribal group has held from time immemorial and never been dispossessed of, and they hold that land by usufruct. If it's a reservation, most of the time the land is held communally with some allotments within it, at least in our experience in the Dakotas. And then allotted lands are just allotted, and we're allotted in fee title but still remain in Indian country. You may think of Oklahoma and what's happened after McGirt as an example of that type of land. Now, what happened before the advent of the guidelines is tribal judges or federal judges sitting in cases involving Indian country claims would apply the common law of sentencing that arose out of the states, right? Because the way that it generally worked is that, you know, we have the Major Crimes Act and we have the Assimilative Crimes Act. Under the Assimilative Crimes Act, very few of those crimes have any corresponding guideline directly within the guidelines, and so we go out and try and apply the closest guideline because that's what 2X 5.1 tells us to do. And what happens is a body of law develops rather quickly that the judges are applying these guidelines, and the reality of it is when there's a new crime enacted, we go through this process, appeals are taken. We're actually very rarely reversed by the courts of appeals. And then there is a body of common law that develops as to what's the appropriate guideline. Now, I don't want to tell you it's always easy because you will know from my September letter to the commission when we were talking about the priorities that we thought, we asked about, let's take a look at 2X 5.1 as it applies to crimes against children, child abuse, and how it applies to sex abuse crimes in Indian country. And the reason for that is that they don't match up very well, and judges have had a difficult time. Now, there's an explanation for it. Usually what happens is that you can be charged with a child neglect case that's just, you know, very kind of garden variety child neglect, or you could be charged with having starved a child to death, and a death is ensued. They're very different crimes, and so what ends up happening is you may have the same judge applying separate guidelines back to back within 2 weeks. And on the outside, if you're sitting here, like all of the people here that work in the Sentencing Commission, they look at the statement of reasons, they look at the judgments, they look at the pre-sentence reports, and they're saying, how do we make this fit statistically? And frankly, as judges, we worry little about how it fits statistically when we're looking at, we have a dead child here, and we have a child that maybe was, you know, just, like I say, garden variety neglect. And they're just very different cases, and they result in very different sentences, and they don't account well on the guideline, on any of the documents that we put together when we sentence people, right? In any event, the bottom line is that as a group, the members of TIAG have a long experience in dealing with sentencing by looking for the most analogous sentencing guideline. And we have found it to be a workable process. The people who've spoken earlier who said that there will be litigation, it's true. There will be a transitional period where we will litigate these issues, but these crimes will be identified, you know, case by case, and we never really go visit them again, right? For example, you know, I haven't had anybody argue about whether or not what guideline we should apply to a robbery conviction in the 14 years that I sat as a district judge in North Dakota, because that was settled law. Everybody knew what it is. The law will settle. It will be, we'll be able to address it. And I've gone over what I should, but that's really the point that TIAG wanted to bring here, was that it's not as unworkable and it's not as terrifying as it appears in real life. Any questions?
Oh, well, any questions? That's right. I've been misled.
Okay, sorry.
I'm sorry.
I don't know what I'm doing.
Mr. Luria, come on.
Sorry about that, Ms. Susan.
Oh, no problem. I learned a lot from that. I know nothing about the Tribal Issues Advisory Group.
I'm a circuit judge. I think I'm the center of all attention.
And a district judge would never cross over you.
I don't know how I did that.
That's fine. No, it's fine.
Chair Reeves, members of the Sentencing Commission, thank you for the chance to be able to be here to provide testimony on behalf of the Practitioners Advisory Group. The PAG is a group of individuals who practice in the private sector who represent people and organizations who are charged with federal criminal laws. We appreciate your willingness to consider our perspective. I'm going to touch on Part A, B, and C of the proposed amendments to the Career Offender Guidelines, and I'm going to start with Part A. We recognize all of the criticisms out there about the categorical and the modified categorical approach. However, even with all those criticisms, the PAG is unable to support Part A of the proposed amendments. The Supreme Court has explained the rationale for the categorical and modified categorical approach. In Mathis, the court stated, an elements focus avoids unfairness to defendants. Statements of non-elemental fact in records of prior convictions are prone to error precisely because their proof is unnecessary. That reasoning explained in Mathis, in our opinion, applies equally in the guideline context. Going beyond the elements to look at the manner in which a prior offense was supposedly committed invites uncertainty and unreliability in how the guideline is applied. The actual conduct underlying a prior offense is often not clear from the documents that are available for the court's review. Moreover, the documents, or the plea colloquy even, often reflect only the police or the prosecution's version of how the underlying offense supposedly occurred. For strategic reasons, or in the context of plea bargaining, a defendant and his or her attorney may choose not to contest alleged facts that simply are not material to the elements of the offense or to the ultimate outcome or the plea negotiation reached in the case. Yet the proposed amendment would allow a sentencing court to rely on such immaterial alleged facts. Take, for example, a prior assault conviction. The underlying police report or charging document may allege that the defendant used some degree of force to commit the offense. But because of proof concerns or evidentiary issues, the prosecution may agree to offer in state court the defendant a plea deal to a lesser charge involving a negligent or a reckless mens rea. In those situations, under the proposed amendment, what controls? Is it just the actual offense of conviction? Is it what is contained in the charging document? Is it the purported facts as read out loud by the prosecutor during the guilty plea hearing? In PAG members' experience, the prosecution may want the defendant to not contest certain facts in order to resolve the case with a lesser offense. Or the defendant's attorney may advise the defendant that it is not necessary to contest the prosecution's version of the offense since it is not material to the ultimate outcome in that particular case. This type of plea bargaining and plea proceeding is pervasive at the state level. The PAG believes the Commission's proposal will create confusion and uncertainty over how such prior convictions are considered under this guideline. Additionally, certain prior offenses, which should never be classified as crimes of violence, may be classified that way simply due to immaterial and inaccurate allegations that were not contested at the prior state proceeding. Moreover, the Commission's current proposal will not actually eliminate the categorical approach. I believe prior speakers have already talked about that. The current proposal appears to employ both a categorical approach and an alleged conduct-based approach in determining what federal sentencing guideline most closely matches a prior state offense. A sentencing court and the parties will still have to engage in the categorical approach under certain recidivist statutes, such as the Armed Career Criminal Act, before moving on to a more conduct-based approach under the Part A of the proposal. For all of these reasons, and for reasons that are more detailed in the written testimony and the comments which we will submit, the PAG does not support the Commission's proposed Part A. Moving on to robbery, I'm going to speak more quickly. With regards to the proposed amendment to the definition of robbery, we ask you not to adopt the amended definition. Multiple courts have explained why Hobbs Act robbery does not constitute a crime of violence. It's a substantive amendment to expand crimes of violence to violence against property only. Under the proposal, crimes that do not involve violence towards another person, such as vandalism or criminal mischief, could potentially qualify as crimes of violence if they were coupled with a demand for money. I have examples if you would like to ask about them. Inchoate offenses, Part C. PAG believes that inchoate offenses should not be considered crimes of violence or controlled substance offenses for the purposes of the career offender guidelines. In a nutshell, they are substantively different. A state of mind, intent, a mental agreement can all constitute inchoate offenses, sometimes even without an overt act or substantial step. Even if it requires the overt act or a substantial step, it could still be far from an actual completed offense. So we ask you not to adopt that proposal either. Thank you.
Mr. Luria.
Thank you. Good morning.
Good morning.
On behalf of the Probation Officer Advisory Group, we appreciate the opportunity to provide testimony regarding the proposed amendments to the career offender guidelines. At the beginning of POAG's consideration of the career offender amendment, there was a threshold question. Do we continue with the elements and enumerated clauses or not? So I'm going to start off with something that seems obvious to me. The current definitions do not work well. They produce odd results, often and in every jurisdiction. The best arguments I've heard for keeping them is so that we don't have to engage with two separate processes for career offender and armed career criminal. POAG does not think that reason is sufficient to continue with a structure that is not working well. The current definitions have created such problems that POAG was nearly unanimous in support of the new listed guideline method. In our written testimony, we shared an example of Florida's battery on a law enforcement officer as compared to resisting arrest with violence. However, today I wanted to share another example of how the new method could improve the career offender application. We've had several cases dealing with sexual battery under Florida statute, section 794.011 sub 5. These cases have horrendous facts, many of which are well documented in the charging instrument. However, because the statutory definitions include an indivisible clause that has penetration by or union with, the offense is not considered a crime of violence. Under the new proposed system, the judge would be able to look at everything from the Shepard document, not just the statute reference, and they would likely end up connecting this conviction to section 2A3.1. The offense would then be considered a crime of violence predicate. This is just one example from one jurisdiction. There are hundreds of similar stories of where the current method continues to fall short of capturing truly violent conduct. All of this, and we haven't even touched on controlled substance offenses, which are seeing similar categorical approach arguments. The listed guideline method is widely untested, and it will likely lead to litigation. However, the current method has led to litigation and is currently still being actively litigated. As we have an adversarial system, litigation is always and should always be a part of the structure of things. However, we believe the new listed guideline method will produce a result in which the conduct that is truly violent or has the potential to lead to violence is better captured as a crime of violence. If this new method is adopted, we will have two processes to apply. But POAG believes that the new career offender method would actually work well. So while there will be litigation, that litigation will at least be within a better system. The change to a listed guideline approach in 4B1.2 is also really good. And by that, we don't just mean well written. POAG thinks it moves us closer to what is just. As such, POAG supports it as better than the current structure. POAG reviewed the documents that would be relied upon and agrees that sources expressly approved in Taylor and Shepard should continue to be used. POAG recognizes that there are 3 other proposed amendments that are made as mutually exclusive to the listed guideline method. While we are in favor of many of the changes suggested in Part B through D, our first choice is still the new listed guideline approach. POAG is in favor of adjusting the definition of robbery as noted in the proposed amendment. We believe it will help resolve the disparity on the issue amongst the different circuits. For continuity's sake, we also recommend that this definition be mirrored in Section 2L1.2. POAG is also in favor of the Commission defining the phrase actual or threatened force for the purposes of the proposed robbery definition based on the Supreme Court's holding in Stokeland. POAG is in favor of the adoption of the inchoate offense amendment. POAG prefers option 1 because it is a simpler approach that eliminates the need for a 2-step analysis. POAG believes inchoate offenses should receive consideration regardless of whether an overt act occurred or what overt act is required by the state law in question. POAG also likes the idea of including this and other adjustments into the main body of the guideline rather than the commentary, as we believe this also reduces circuit application differences. Lastly, POAG supports the inclusion of offer to sell and the Title 46 offenses in the controlled substance offense definition. We believe this will further alleviate jurisdictional differences. Again, thank you for the opportunity to share POAG's perspective, and I'm also ready to answer any questions you have.
Thank you. Turn now to my fellow commissioners. Yes.
Thanks so much to all of you for your testimony. My first question is for Judge Erickson. I wonder if you have any experience with assault, specifically the sort of primary example of a concern that both the executive branch and the defenders gave to us was the complications of applying state assault offenses in the 2X 5.1 context.
Yeah, if you look at the assault offenses, I would say that, the second or third most common crime that we see out of Indian country cases is assault, and we've developed over the years an approach that to the guidelines that has not been particularly complicated. I said it was the robbery guideline before that nobody litigated. Actually, I meant the burglary guideline that no one ever litigated. But the reality of it is those things you see every day, we sort through. And there's, all the judges that sit in North Dakota, there's, they get to the same place. The guidelines are the same. The probation officers come up with the same guideline range. And then the discussion is like it always is. And so, I think that I don't know how to say this other than to say, look, 30% of my caseload when I was United States District Judge was ordinary street crime. I've tried felony DUIs as a United States District Judge, right? That's a weird thing, right? You can look in the guidelines all you want to the end of time, and you're not going to find anything that helps you with that, right? But, you get used to sort of working without a net. It's not all that difficult. We're judges. We're in the business of making decisions, and the body of law is developed. And in some ways, those things that are fairly unpredictable are more easily addressed. The biggest problem that we get, the biggest complaint we get in Indian country is that Native American people are being treated differently than state defendants who have committed the same crime in the same place, sometimes together, right? Because the burglary sentences or the robbery sentence is longer in federal court than it is in state court. So you have two people, they commit a robbery together. One's an Indian country with an Indian in Indian country with an Indian victim. Man, that's a federal crime. It's not going anyplace else. And so there we have it. And the co-defendant gets the same, is in state court, and because they happen to be non-native, and so it's just that's the bigger problem for us. Now, I think that if you look at the uniformity of sentencing, that's going to be the problem. It always is. But I look at the uniformity of sentencing. The biggest problem is not that somebody complains to the federal judge in Fargo that there's those people in South Carolina are getting much shorter sentences. It's more the claim that the people who have done exactly the same thing and who would not have been in federal court but for their membership as an enrolled member of a tribe, that they're doing twice as long. And it leads to untoward results. It leads to, the federal government choosing not to prosecute crimes that would otherwise be prosecuted in the states. And so people tend to think they can get away with things if they're not prosecuted. And so we go from people are getting 10-day sentences in tribal court and then sort of full stop, go away for 7 years, and there's nothing in between, which doesn't really happen other places, right? So I don't know if I answered your question, but
That's very helpful. Thank you.
Yes. Commissioner Wong.
My question's for Ms. Lynn. Thank you. Thank you for being here. My colleague Judge Restrepo sings your praises. Ms. Lynn, the Department of Justice framed their concerns or reservations about the listed guidelines approach in terms of a preference for an actual conduct approach. And you had talked in your testimony about some concerns with even the listed guidelines limited sort of window into actual conduct through looking at the Shepard documents, saying that swept in sort of immaterial facts from your perspective. I'm curious, do you have, between the actual guide, would your concerns be exacerbated by a full-on actual conduct approach?
Let me see if I understand your question correctly. Is Part A preferable to a full-on actual conduct approach? Without having spoken with other members of the PAG with that qualification, I don't think it's possible to implement an actual conduct approach fairly. So then by default, my answer has to be yes to your question. But I would say that even under Part A of the proposed amendment, there seems to be a window that allows for looking into documents even outside of the Shepard documents. The language of Part A it doesn't seem like it's written strictly enough to be to look only at what the Supreme Court has said one can look at in Taylor and Shepard. So that does cause me concern with the current language of Part A.
Can I follow up on that? When you said, I know just speaking for yourself, that an actual conduct approach cannot be implemented fairly, what do you mean by that?
Precisely because of the difficulties I explained in my testimony, in order to look backwards into what happened in a prior offense that may have happened 10 years ago, 15 years ago, even closer in time. In order to do that right and do that fairly, one has to basically bring in all the parties in and have a full-on hearing at that point in time. When you're in state court doing a plea, and frankly, these are some people who there are attorneys in the room who are often handling multiple defendants all at the same time. It's a list room. There's a good deal on the table. You just grab the deal and you go. You're not looking at what exactly is read out loud into the record, as long as it satisfies the elements and the judge is satisfied and the prosecution is satisfied, the defendant is satisfied by the deal that's on the table. Nobody's thinking about the possibility that some fact, some accusation that seems immaterial at this particular time may come back and be material 10 years down the road in a way that nobody anticipates. So given that is a common phenomenon in state court practice, I don't know how it's possible to implement an actual conduct approach fairly without full-on litigating every single past conviction.
Ms. Lynn, it's good to see that Philadelphia is well represented here today.
With Mr. Zalzner, yes, it is.
Pennsylvania.
Yes.
Just to be clear, a lot of confusion out there. We've heard testimony from some of your colleagues, and I'll ask you the same question I asked Ms. Scott in terms of common ground with the department. So I understand your criticisms of what we've proposed. How do we fix it? And what common ground do you think POAG would have with the department's positions, if any?
So I'm going to put this out there. I don't know that a fix is required. So it is clear that if the elements of a prior offense match the definition of crime of violence, then it's a crime of violence. And there are definitely statutes out there where the elements of the offense fully match the elements of crime of violence. So you're looking at the outliers, right? You're looking at the things that I would suspect the Department of Justice would say are mere technicalities. They're the loopholes. They're the things that aren't captured by the current definition of crime of violence. And for those, I would call anomalies or exceptions, that is where the ability to impose a variance comes in. That is within the discretion of a district court judge. So yes, there's a lot of litigation. There's going to be a lot of litigation no matter what. We are all lawyers. We're judges. Well, you all are judges. That's what we do. It's going to happen. That's what happens when you have people who are rightly so advocating for their particular positions. We should not be afraid of that litigation. It is okay for a sentencing judge to calculate the guidelines using the categorical approach. And if they think that the ultimate result does not match what actually happened, they can put their reasons on the record for an upward variance. Judges have done that before. Judges have said, this is what it would have been under the career offender guidelines. For this reason, I don't think the career offender guidelines apply, but I'm going to impose this sentence because I think the non-career offender guideline is not appropriate for this particular defendant. Do I like it when that happens? As a criminal defense attorney, maybe not, but I think that that is how this situation is fixed.
What about the severity issue with respect to the career offender guidelines? There's a lot of talk about the severity issue. Does POAG have a position on that? And if so, what should we be looking at?
So, PAG definitely. You want me to join you? I'd be happy to.
I'd like to hear that same question to Mr. Lawyer.
So I'll be brief. I feel confident that PAG agrees that the career offender guideline is too severe. I'm a little worried about 994, the language of 994H and its requirement that certain people have sentences close to the stat max. I think the fix there is to restrict how many people the career offender guideline covers. But yes, absolutely, I agree. Overall, given the number of variances that happen across our country, I think everybody agrees the career offender guideline is too severe. I'll pass it on to Mr. Luria.
As for POAG's take on that, we would certainly be interested to see what you were to come up with related to that. We're kind of focused on fixing the front end perhaps instead of the offense level outcome. However, it's hard to ignore the 2016 report that's been talked about extensively already. I've personally heard that brought up in court numerous times since it came out, and there's a lot of validity to it. But from our end, I think when we talk about it being a more just circumstance, it's really about, can we actually capture what's actually violent? The other component within that is it's unclear whether these are too high, or is there such a disparity occurring in terms of the definitions that judges are unwilling to rely on it. So it's kind of unclear to me which one is really driving that. It's probably an amalgamation of the two. So I'd love to see what you come up with, though.
Commissioner Wroblewski and then Vice Chair May.
Thank you so much. And thank you all for being here. We really appreciate your testimony and you taking the time to come here. Ms. Lynn, I just want to follow up a little bit on your position.
Just make sure you speak.
I'm sorry. And I really want to, I'm curious if I just want to explain sort of how I see this, and then I want you to tell me why I'm seeing it wrong or why you think maybe I'm seeing it right. So it seems to me that with the career offender, there are several elements that we're throwing all together. There's fact-finding, which judges do all the time. There's the timing of the fact-finding. So in other words, when the fact apparently happened and that the judge is looking at. And then there are the sentencing consequences that result from the fact-finding. And I think we're all in agreement that at least for subset of career offender, the sentencing consequences are trouble. And that, I think, has some effect on our thinking about fact-finding. And let me tell you why I think so. The guidelines are full of factors that judges have to do fact-finding on, full of them. And we basically, typically, under Chapter 6, rely on judges to look at any reliable evidence to do that And there may be litigation or not, but there aren't typically mini trials at sentencing. There are contested facts. We have a process under Rule 32 of the Federal Rules of Criminal Procedure. We go through that process. Sometimes we have to call witnesses, sometimes not, but it seems like we've adjusted to that world and we've lived with that world. So fact-finding, it seems to me, which is the conduct approach, which is what you're calling it. I'm now just calling it fact-finding. It seems like in most situations, we've been able to deal with that related to the offense, which is most of the factors that are listed in the guidelines. But then you have this special category, which is prior offenses. And those prior offenses could have happened a year ago, 5 years ago, 10 years ago, 20 years ago. And that makes the fact-finding a little more difficult. And then, of course, we have the sentencing consequences. So I put that aside. We've dealt with that. We're going to go arm in arm to Congress. But on the fact-finding with the priors, what if we created a system that says, Judge, if your fact-finding deals with a prior conviction, in other words, something that happened 5 years ago or more than 10 years ago, and we said, in that situation, we want you to find the facts more than by a preponderance of the evidence, but perhaps by clear and convincing evidence. So we raise the standard of proof for that fact-finding, which may have happened some time ago, but otherwise we rely on the same kind of fact-finding we do in all the rest of the guidelines areas. And if we address the consequences, so instead of it being taking someone from level 20 to level 35, as we may do in career offender, it's more of a modest thing. Is that the kind of world that you could live with, that you would think was more sensible? And do you think that this framework of thinking about it makes sense?
I don't think I'm going to have a definite answer for you right now. I have to be honest. It's an interesting proposal. I am slightly worried about the idea of having anything that was involved in a prior conviction that could so severely raise, and I'm going to get to the adjusted sentencing consequences in a minute, but that could so severely raise a potential guideline range be found only by clear and convincing evidence, right? Like, it seems to me that anything that greatly increases a defendant's potential exposure to prison time at some point in time, to me, becomes just as important as an element of offense, just because of the consequence. The jurisprudence out there may not agree with me, but that's how I feel about it. Now, you coupled that, though, with the idea of lowering the potential sentencing consequence. It's an interesting thing to think about. I don't have a response right now as to whether or not I think it's great or not, but it's something that I would want to think about a lot more, and I would certainly discuss it with other people.
Thank you.
Yeah.
Commissioner May.
Thank you all for being here this morning and taking the time to talk with us. I'm moving from that big question to a really little question for you, Mr. Luria. There was something in the written testimony about there should be further assessment of whether some of the listed offenses should be included. Was that a concern that some of them might be overly broad and sweep in things that shouldn't be there, or can you explain a little bit more about that?
Yes, ma'am. During our discussion of the listed offenses, one of the ones that caught a lot of people's attention was threatening or harassing communication, hoaxes, stalking, and domestic violence. That one caught a lot of people's attention as possibly being, maybe something that wasn't capturing something that wasn't necessarily as risky of violence. I know in the New England area, there's harassing is kind of a misdemeanor felony. That's kind of a odd misdemeanor felony structure sometimes. And there was a concern voiced that they might be kind of catching something that is not a very severe offense in some jurisdictions because of the name and because of the elements of it, but could end up on a list here that's treated much more severely. We also talked a little bit about the firearms component here too. One of the thought processes that we kind of looked at with this is there's going to be a wider expansion of career offender because of this, because the instant offenses will now be predicates that allow for career offender consideration to come in. So while we were discussing 2K 2.1, for example, one of the members was talking about what would happen if you had these circumstances where you had a person who had a machine gun or a short-barreled shotgun. Well, that's on the list here as a firearm under 5845A. And if that person has a base offense level that has 2 crimes of violence or controlled substance offenses, well, they're now no longer really under the 2K2.1A. They're actually going to be under career offender. And so, kind of looking at that and seeing this list also kind of impacts a lot of other areas that aren't necessarily connected directly with predicates, but also how instant offenses are considered.
Thank you.
Yes.
One more question.
Yes.
This one for Judge Erickson. Thank you for all of the work that TIAG does. It plays a super important role and is a unique body in your work. We really appreciate it. And this maybe goes outside the scope of what you're prepared to talk about today, but since it kind of came up, I wanted to ask, you raised the issue of the disparity between state and federal sentencing in Indian country. And I'm wondering whether there was any discussion in TIAG about this proposed listed approach, which would expand the number of offenses that qualify as career offender predicates, whether that would have an adverse impact on Native American individuals.
We had discussion, and we arrived at no consensus. It boils down to this: if you just think about it, we're going to sweep in more offenses, and so you're going to expose more people, and we already have a severity and disparity problem. But that disparity problem, as I described it, is that's only half the problem. There are states in the United States where the federal sentencing guidelines are less severe than the state sentencing practices, right? And so, it's kind of odd. Everybody in Indian country operates in their own little sphere, and we're, geographically, we're thousands of miles apart. And so where we sit in the northern Great Plains, Montana, North Dakota, and South Dakota, there's a widespread belief that the sentencing practices are unduly harsh in comparison to the state sentencing practices. You can go into the desert Southwest and it gets really interesting, because in Arizona, the perception is that the state sentences are more severe than the federal sentences. You cross over to New Mexico and they see the world like we see it, that generally the sentences in federal court are more severe than state sentences, right? And so that disparity problem is a real problem. It's hard, if we're trying to look at uniformity. So I don't have a very good answer for that. I just want to make sure you understood that within TIAG itself, there's sort of a broad sense of that we disagree because we have different circumstances on the ground.
Commissioner Gleason has a question, and I have a question after that, so we may be going a little bit longer unless Gleason asks a question that I want to ask. Commissioner Gleason, you may proceed, sir.
Thank you, Judge, and thanks to all 3 members of the panel for your contribution and for taking the time to appear. I wish I were there. I just really have an observation that I welcome a comment, any response to from any or all of 3 of you. And it's this, we all bring our baggage to the table, and the older you are, the more baggage you bring. And I'll confess that mine includes 10 years working as a prosecutor with police and relying on them, and I thought they were great. And I would, there was a point in my life when I thought you can retrospectively find facts based on police reports, and you can take that to the bank. And I'm also on the panel now in the CJA panel in the Southern District of New York. I recently had this case where my client got arrested on a violation of supervision for assaulting a cop. And 2 cops came in and said that when they broke up a fight, he assaulted them. And I was just about to plead him guilty when I found out there was a recording made by someone in the neighborhood. And it turned out the cops had assaulted my client. And the AUSA immediately dismissed the violation. Now this client of mine's a pro bono client in a 1983 case, and working out a settlement with the cops who assaulted him. So I've been on both sides. I question the ability, if you take that reality and you take the vagaries of plea policy, of plea bargaining in states, and, it was previously mentioned that sometimes you just take a plea that looks like a favorable outcome without challenging police report recitations of what happened in the crime. So I'm really troubled by the accuracy. I believe in real offense sentencing. I believe in basing sentences on actual facts. But I have great concerns about the reliability of using the documents that some would say could properly be used to determine what the real offense was in a prior conviction. And I just wonder if there's any comment by any of you as to how we reconcile those problems and those experiences. I'm wrestling with it, I'll be honest with you.
Whoever wants to start off first.
I
Judge
guess everyone's
Erickson,
looking at me. I think that's really the $64,000 question, right? I mean, the bottom line always is, and if you're sitting there and you're the trial judge and you're about to sentence somebody, and you realize that there's been a plea bargain made in a state court where somebody's pled somebody in a way that's creating a huge problem for you now, and the question is, what do we do with variances and how do we make that work? I mean, that's a problem, right? And there's another problem that and obviously these are all my views, not TIAG's views. There's another problem if you just think about it. The further back we start to look, the more likely all the records have been purged, and we don't really know anything beyond what's in the documents of conviction. I mean, I started being a judge in 1993, so it's been a long time, and I can go back, and when I first started, I mean, we had transcripts going back to the 1870s, and all the files were still intact, and nobody ever purged anything. We just had these musty old rooms, and now they're all gone. And we're going to have a whole series of problems trying to figure out, what's out there and how does it work. Is it unworkable? Probably not, because in the end, what do judges do? Well, we judge, and we make decisions based on the burdens of proof and the standards that we've developed in the law of sentencing generally. But whatever we do, there are going to be difficulties.
I think Commissioner Gleason said anyone else who wishes to chime in may do so.
So I don't think this is going to be very popular. But the dilemma that Judge Gleason referred to, it's sort of one of the reasons why the categorical approach came up in the first place, right? Is because the only thing that's truly reliable is the elements and what had to be proven in order for the conviction, or had to be admitted to in order for the conviction to be entered in the first place. So in a way, it's almost like we're going in a full circle to be revisiting this again. Not popular, but we got to wrestle with that too.
Thank you, Ms. Lynn.
I wouldn't go as far as that, perhaps, but I do think that we've kind of landed on recommending Shepherd documents. I think a lot of this has to do with the most appropriate guideline component of this, hopefully smoothing out a lot of these more de minimis components with some of the additional information that's in the Shepherd document that would help the court figure out kind of what happened in that a little bit more of a controlled structure, versus instead of going straight to police reports or something along those lines. Those Shepherd documents don't always provide that information, but they frequently do give a lot more insight than we're currently allowed to consider. Some of the things that we also discussed was the prospect of using third-party information, and along those lines, we were not able to get to consensus on it. But we were, one of the things that was discussed was, what about medical records for victims? It's not always in the court file, very frequently not. But when it is, oftentimes it's very kind of dispositive on the kind of injury that occurred, descriptive of the kind of possible attack that had occurred as well. And it's medical. It's not intended by one party or another to create culpability, simply a report of what happened to the the victim. But again, we were not able to come to consensus on that. We've also written historically in 2018 on this, under different circumstances, of course. And a lot of the focus on that was still on vetted by the court, documents that were vetted by the court. Additionally, documents that were sworn under the penalty of perjury. And I've heard other individuals say that all police reports are kind of like that. That's not really all police reports. A lot, but not all. From Judge Gleason's example, it sounds like the officers who lied in that circumstances are certainly receiving some court-related attention for that conduct appropriately. So all that to say, I think that staying with Shepard within this structure that's being proposed is where POAG is currently.
I did say I have a couple of questions, but to address that last point, Judge Gleason mentioned a 1983 action, which is a civil action.
Okay.
So yeah. There are many more tools in the shed for people who lie under oath. So, but that's for another day. My question, Ms. Lynn, to you. I thought you were here when the federal defender testified, and I thought she made some very compelling points about disparity and baking in the disparity and driving racial disparity, that sort of things. You also, the Practitioners Advisory Group, she was coming from the federal public defender sort of view. Do you have any comments about that aspect of what she was saying? Have you found that a sort of similar thread in the types of people you represent, the type of people you teach, the observations you see?
Absolutely. I completely agree with the things that Ms. Scott was describing in her testimony regarding the racially disparate impact of the career offender guidelines. It does fall more heavily on Black and brown defendants, and frankly, more heavily on Black defendants. As a private practitioner, I absolutely see that in my clients. I take a lot of CJA appointed cases, which means a lot of my clients don't have a lot of money. And hey, guess what? It coincides with a lot of, they just happen, many of them are people of color as well. It's impossible to get around how much the impact of the career offender guideline falls more heavily on Black and brown defendants. And yes, we agree with her.
Oh, I'm sorry. And a lot of that could be attributed to the state prosecutorial decisions made in various communities as well, right?
Yeah, so there's absolutely the systemic idea that if locally, in a certain neighborhood, in a certain zip code, in a certain city, if certain areas are policed more heavily, then convictions of individuals who live in those areas are going to be higher than individuals who live in other areas. And if individuals who live in those areas more likely are Black and brown, then you see how this system gets perpetuated and how the disparity that may start at a state and local level, if the federal system looks at those state convictions and uses those state convictions to calculate the criminal history score and therefore drive up somebody's potential sentencing exposure, you see how it all is baked into the system. I don't know how we get around that, but we certainly don't get around it by increasing the number of people who are impacted by the career offender guideline, because that just seems to me to exacerbate the problem of racial disparity.
And I see it in a different way, in an additional way, back in my home state with no real indigent defense system. Nobody investing in the indigent defense system, which leads to a whole host of issues of persons pleading guilty to certain crimes that maybe they didn't do, or a whole lot of things. The other aspect I wanted to ask you, you made, Ms. Scott alluded to the testimony of her colleague yesterday with respect to the types of research that could be done. She just alluded to it. She didn't specify, but I think it was Miss I forget the Miss Scott. That was Miss Scott too. Okay. She gave an account of various categories of things that the commission can research to expand to sort of get more data, more research, more knowledge about things. Has the PAG talked about what other type of research, if any, the commission could sort of direct to help try to address or try to figure these issues out?
So I have to confess that I don't remember conversations specifically about the career offender guidelines and what additional research would be helpful to that, other than a update, I guess, of the 2016 report. So I could take that back to the PAG, and absolutely we can address that in our written comments.
Okay, thank you. Any other comments, questions from any other commissioners? Thank you, Ms. Lynn. Thank you, Mr. Luria. Thank you, Judge Erickson. It's now time for us to take our morning break. We're still doing good with respect to time. Our commissioners, again, we've been working, we will work. We'll take about a 15-minute break, so everybody should be in their seats at least by 11:40. That's a little bit more than 15 minutes, but be in your seats by 11:40, we're good. Thank you so much.
Thank you, Your Honor.
For those who are tuning in, I know yesterday there was jazz playing during the intermission. I hope that's the same as today. Welcome back. I'd like to introduce our fourth panel, which will present the executive branch's perspective on our proposed amendments regarding the use of criminal history. To present that perspective, we have the Honorable Philip A. Talbert, who serves as U.S. Attorney for the Eastern District of California. Mr. Talbert has spent over 20 years in that office, where he has spent time supervising the office's appellate practice and training incoming assistant U.S. attorneys. Prior to his time as an assistant U.S. attorney, Mr. Talbot worked as a trial attorney and assistant counsel in the Department of Justice's office in Washington, D.C., including a time as associate counsel at the Office of Professional Responsibility of the Department of Justice, where he investigated claims of prosecutorial misconduct and other allegations made against DOJ attorneys. Mr. Talbot, thank you for coming. We're ready when you are, sir.
Great. Thank you, Chair Reeves, Vice Chairs, and Commissioners. My name is Phil Talbert, and I have the honor of serving as the United States Attorney for the Eastern District of California. We understand your concerns and appreciate your goals. The Department supports including convictions for the simple possession of marijuana without an intent to sell or distribute as grounds for downward departure. The Commission's proposal is consistent with the President's views that no one should be in jail for the simple possession of marijuana and his pardon proclamation. It will also account for the many jurisdictions that have decriminalized personal use marijuana possession. We have a different view on status points. Status points have been part of the guidelines since 1987. Since 2017, about 37.5% of all offenders have received status points. The Department wants to better understand and consider the Commission's analysis of status points and recidivism in its June 2022 study before the Commission made such a significant change. Our concern is that the amendment lacks sufficient empirical bases. The June 2022 study may not have used widely accepted methodology, and the data set is not public, and there's been no independent analysis. A more rigorous recidivism analysis is appropriate. And as the June 2022 study suggests, status points may actually have a meaningful relationship to recidivism for 40% of all reoffenders. The Department also notes that any proposed amendment to Section 4A1.1 should meaningfully address the guidelines' twin goals of recidivism reduction and just punishment, and not solely focus on recidivism prediction. If the Commission were to adopt one of the proposals now, we believe option 1's retention of the current provision with the new downward departure language offers the best option. We strongly disagree with option 3's elimination of status points, even with additional upward departure language. The Department opposes creating a new 0-point offender criminal history category and a presumption of non-incarceration for those offenders. We appreciate the Commission's interest in leniency for first-time offenders, but this significant change would presumptively sweep in defendants who committed serious offenses, including hate-based or civil rights offenses, public corruption offenses, national security offenses, and serious economic and corporate crimes. As an example, in 2021, offenders with 0 criminal history points included 11 convicted murderers, 119 sexual assault offenders, 53 robbery offenders, and 454 offenders with convictions for assault. These offenders should not be rewarded a 2-point reduction. District courts already can and regularly do vary downward for true 0-point defendants. Only 38% of offenders with 0 prior convictions receive a guideline sentence. The Commission's data shows that courts already are, on average, effectively varying down by 11 months. The Department supports a district court exercising its discretion to do so in an appropriate case after a careful review of the specific facts. In contrast, this new Category 0 would add complexity and litigation to sentencing. All proposed options would potentially include up to 6 different exclusionary criteria, leading to increased litigation over whether one or more apply. These changes would affect up to 17,000 defendants a year, or over 32% of all federal offenders. Such an across-the-board departure for offenders will undermine general deterrence and respect for the law. If the Commission were to proceed, the Department believes a 1-level reduction is consistent with the guideline structure. but this benefit should be limited to offenders with no prior convictions ever and include more robust exclusionary criteria. Regarding Section 994J, as we did in 2018, we support the Commission's desire to implement Section 994J faithfully, but we disagree with any categorical presumption of non-incarceration. We believe the current sentencing regime already fulfills 994J's mandate through sentencing table zones, variances, and departures. Through individualized assessment, courts are always able to offer a non-custodial sentence when appropriate. The Department appreciates the opportunity to provide our views and looks forward to continuing to work with you. I look forward to your questions.
Thank you, Mr. Talbot. I turn to my commissioners. Anyone wish to accept his invitation? All right, Vice Chair Murray.
Thanks so much, Mr. Talbot, for your testimony. I had a question about the department's suggestion that in the context of 0-point offenders, if we were to go with 0-point offenders who have no criminal history points rather than no convictions, that we back out folks who have a prior violent offense. Do you have a way of doing that without resorting to the categorical approach?
Well, unfortunately, when we get into this, it will require more litigation. Our suggestion is that the Commission has already proposed a number of exclusionary categories. In our view, those exclusionary categories are much too narrow. For example, the violent crime one focuses only on the defendant's own conduct and doesn't consider whether the defendant might be part of a group that under the law, groups can cause even more harm that's recognized than others through conspiracy and that. Other categories like the covered sex offense excludes the trafficking of child sex abuse material, which the department thinks of as a very serious offense that if there were exclusionary categories, all of that would be covered rather than a narrow category.
And in terms of violent priors, if we were to exclude people with violent priors, is there a way to do that without resorting to the categorical approach?
I don't see that. There would be increased litigation. There'd be arguments over whether something fit with the elements, and we'd have the situation come up. And I listened to Judge Erickson's testimony earlier, where judges are in the business of judging, and they want to look at the facts in front of them and make decisions, but. Sometimes with these layers that come in that are created for them, it causes one, unnecessary litigation, but also unnecessary decision making on their part.
Thanks.
Back to the 0-point offenders. Does the department have a position with respect to, well, for lack of a better term, a true 0-point offender, someone who's never had any contacts whatsoever with the system?
So the department thinks that the current guideline structure already accounts for and allows judges sufficient discretion to deal with true first-time offenders. And in fact, that's why we cited the statistic that only 38% of true first-time offenders receive a guideline sentence. So most are receiving, and the vast majority of those are varying downward below that. So judges are already looking at that. Many of these first-time offenders fall in Zone A anyway, and so they're eligible for probation. And the application note 4 to that section says that judges should consider, if it's a first-time offender with a nonviolent offense, the judge should consider a sentence other than incarceration. But that's all one of and that's really in the structure and sense of the guidelines, which is giving judges options. Once they calculate the correct guideline range, it gives judges options as opposed to telling them what an appropriate sentence may be or not.
Commissioner Gleason has a question. I'll turn to him. Commissioner Gleason, you may begin.
Yes, thank you, Judge Reeves, and thank you, Mr. Talbot, for giving us your time and your input. One of the things that has troubled some of the folks who think that 28 USC 994J hasn't been implemented and you've already touched on this a little bit, is the difference between the availability between telling judges to consider a sentence that doesn't include incarceration, having a sentence that doesn't include incarceration available on the one hand, and then on the other to tell the judges through the guidelines that a sentence of non-incarceration is appropriate. And that's, of course, the mandate that Congress issued to the Commission in 994J. I wonder if you could comment on whether you think there's a difference between making a non-incarceration sentence available on the one hand and telling judges it's appropriate to impose such a sentence on the other.
I'm happy to, Judge. 994J directs the Commission to ensure that the guidelines reflect the general appropriateness of a sentence of non-incarceration for nonviolent first-time offenders. The guidelines do reflect that. So in the Department's view, the Commission has satisfied the command of 994J by making sure the guidelines reflect that. And the guidelines do that through their entire structure. The zones, which make available and provide guidance, like through the application note that I just mentioned, as to what types of sentences should be considered for each of the zones. The graduated offense level system, where more serious offenses causing more harm to the public are accorded higher offense level scores, and then enhancements on top of that. And then asking the judge to, or directing the judge to correctly calculate, even in a post-Booker advisory guideline sentence, the judge has to correctly calculate the accurately the guidelines range before considering 3553A factors and then deciding whether a guideline range sentence is appropriate or varying upward or downward from there. So the operative word in 994J is reflect, and the guidelines through all of those things reflect the general appropriateness, because a first-time offender who commits a non-serious, non-violent offense is likely to be at a fairly low guideline range on fairly low offense level score and fairly low criminal history on both axes, and then the judge, when different types of sentences are available to the judge, then there's a guidance that from application note 4 that non-incarceration in those circumstances is generally appropriate. So that the department would see, if it were interpreted otherwise, that there needed to be an affirmative presumption of non-incarceration in those cases, then the judge would go through the same analysis of correctly calculating the guideline range, would then look at the 3553A factors and make all sorts of assessments as to whether variances up or down were required, would think about what the appropriate type of sentence was given the available types of sentence, but then would have this overlay of, well, does it fit this presumption? And if I think that the offense is more serious, then how do I get out of this presumption? So there's an overlay there that is unnecessary given the structure of the guidelines that are to reflect.
Thank you, Judge Reeves.
All right. Any other questions of this witness? Vice Chair Murray?
Say you were satisfied with the data the commission had put forth, or say you did further analysis, you got the data set, you came to the conclusion that there was no increase in recidivism at any level, not just the criminal history categories 5 and 6, but 1 through 4 for status points. What would the department's position be then on proposals 1, 2, and 3 for status points?
Well, with respect to status points, we are concerned. We are concerned that there's been one study. This is a proposed very significant change would impact over a third of defendants in the federal system. And we've had one study come out last year, which showed a connection for 40% of defendants between status points and recidivism, and then 60% not. So, as you say, our first concern is there needs to be a lot more study before we make before the commission considers making this big of a change. But second, there's another goal of sentencing that is being ignored here, which is just punishment. And the department believes that a sentencing judge should be able to consider the fact that a defendant was on supervision of some kind when the instant offense was committed, and that plays into the judge's calculation of the severity and pattern of the defendant's conduct. So I think at bottom, and I'm sorry if I'm not answering the question. I think we'd have to consider, one, we would want to look and see are status points helpful at all with respect to is there any kind of causal relationship, not just a predictive value, but some kind of causal relationship with that. And so if I'm not sure how the department would feel if there was another study or studies that were independently analyzed and we felt comfortable to say that something that's been part of the guidelines since they started, that there was really no reason to have them from a recidivism perspective. I doubt that's the case, given just this one study and the 40% figure, that it looks like there's some kind of connection. It may be that, I think more likely would be that the commission would find that there were other sub-relationships in there where maybe there are fine-tunes that could happen with respect to status points, where you'd have a range of, and again, this would require analysis that that compared offenders with status points to similarly situated offenders without status points, and then looked at demographic variables, offense level variables, and there may be stronger relationships in some areas than others. And so I think that's probably the more likely outcome, and so I hesitate to guess at what the department's position would be on a hypothetical result like that.
Commissioner May.
Thank you for your time and testimony today. I really appreciate it. I was about to say this morning, but I think we've crossed over. So thank you for hanging in there with us on all of this. On the commission's research, and I had a question. The commission a few years ago did a study on recency points, and based on that study, eliminated recency points from the guidelines. Is there any difference in the methodology of that recency report that was the basis of the commission's study decision a few years ago and the status points study?
Well, I'll apologize and say I didn't read the recency point study in preparation for this. I did read the more recent length of incarceration and recidivism study that had a much more robust methodology and mode of analysis than the revisiting status points one. I know that recency points were eliminated for a number of reasons. One of them being the sense that there was double counting with status points. And so now that recency points have been eliminated, then there is less of a concern that there is double counting with status points. But as far as the methodology of that study, I'm unfamiliar. I didn't read that in comparison or in preparation for this. In comparison, the length of incarceration and recidivism uses a fairly robust methodology with comparing defendants in like categories and to see whether the length of sentence impacted, controlling for all sorts of other variables, had some impact on recidivism, and actually found that it did. And consistent with an earlier study, this one was on 2010 releasees, and the earlier study was on 2005 releasees. And as this report notes at the outset, that the conclusions in each study were very similar.
One follow-up on that, if I may, kind of, again, looking at kind of us making data-driven decisions in what we're doing here. On the criminal history 0, there's commission data that shows much lower recidivism rates for the criminal history 0 category as compared to the scored and 2s. And I guess my question is, right now, that's not reflected. That data difference between the 0s and the others is not reflected in the guidelines manual, right? And this is one way of doing that.
Well, I think, again, if you looked at each of the criminal history categories, each one contains multiple criminal history point total scores. So category 1 happens to join defendants with 0 points along with 1 point, and then so on. And each category groups somewhat dissimilar criminal history defendants together. And even within each category, there are differences, even if you have the same number of points. That you may have one defendant who's a 5-pointer have a very different criminal history, much less serious than another defendant who's a 5-pointer. So again, the guidelines create a starting point, and there have to be categories of putting people together. So at some point, there's always and I know the guidelines manual, when it first came out, had this discussion in the introduction that at some point you have to make categories that bring somewhat dissimilar defendants together into one category. So there is, and the department acknowledges, there's a lower recidivism rate for first-time offenders. But again, as the statistics bear out, district judges are taking that into account, and they are often varying downward outside of the guidelines, and those first-time offenders are often being given a sentence of non-incarceration.
Thank you.
Just following up on Commissioner Main's question, should we take it into account? So I take your point about the groupings, but I think what we found is it's not linear. So the difference between someone with 5 points and 6 points and 4 points and 5 points is pretty much the same. And then all of a sudden there's kind of a dip around 0 points, and particularly 0-pointers who don't have any prior convictions. I wonder if, if you had confidence in the quality of the study and the sufficiency of the study, I wonder if you think that maybe you do in that study, I don't know. I wonder if you think that we should take that into account.
Well, and again, I think district judges are already taking that into account. I think district judges in each case are looking at the defendant in front of them and are considering the nature and circumstances of the offense, and they're also considering the history and characteristics of the defendant in front of them. And so I think a judge who has before him or her a defendant who has a long unscored criminal history and ends up with 1 point is looking at that person very differently when considering them individually than a defendant who is a true first-time offender and is acting accordingly with their, and as the data bear out, lowering their sentence by varying downward.
I have a follow-up question on that. And I understand that the department's position is that should the commission adopt its proposal for the 0-pointers, that it would just lead to litigation. But, as Commissioner May and Commissioner Murray pointed out, there is a fairly substantial difference in recidivism rates which are low, substantially lower for the 0-pointers. Does the department have any other suggestions, other than just saying, it's going to result in too much litigation? Any other suggestions that we might account for that lower recidivism rate for those offenders?
Well,
other than just judges varying, which I understand that.
But I think that's the appropriate thing for judges to do, and they are doing it, and they are considering that the zone is already set up for this, so that many first-time offenders, unless they commit a very serious offense that's going to get them a high offense level, will fall within that zone. And then the judge will read Application Note 4, which says you should consider a sentence of non-incarceration for that. And so I think judges are already doing that, and the data bears that out. The flip side is if to split the category without raising penalties for defendants with 1 criminal history point, then you have to find some place on the left of the chart, and there is no place. And so then you need to drop on offense level, which is really the other axis. We're talking X and Y. It's really the the other thing that the judge is looking at with respect to the offense itself, as opposed to the defendant's criminal history. So there is it does work against the way the guidelines are structured to do that. And the department's not suggesting that we ought to increase penalties for defendants with 1 point. The department is suggesting instead that judges know this, and they're doing this every day.
Commissioner Wong.
Mr. Talbert, you said earlier that in talking about the presumption proposal, that it would be a little bit unclear how the mechanics of that would work, with the judge conducting a guidelines calculation, doing 3553A analysis, kind of evaluating whether a variance might be appropriate, and also you described it as sort of an overlay of a presumption. And I'm just, none of us have a crystal ball, but I'm curious if the department has thoughts on how that will actually play out consequentially in the real world. Do you see the presumption being something that's considered in the guidelines part of that? That then there's the 3553A factor? Or do you think it's sort of the whole analysis is normally done and then there's a presumption? Or do you think it will actually not have any impact? I'm just curious if you've thought about how that will apply.
It's hard to know in advance. Some judges may consider it part of the guidelines analysis, even though it is something that they would consider at the very end when they're selecting the type of sentence to impose, which is generally after a consideration of 3553A factors. And those judges may be driven by the concern over the litigation that would result from figuring out whether exclusionary factors applied. Right, that we would have to litigate whether, subfactor A or subfactor B applied in a particular case, and look back at look at the offense or look at priors. And then other judges may decide that no, I don't really reach this presumption until I've finished the entire analysis and gone through 3553A factors, which statutory requirement, and can take a fair amount of figuring and consideration by judges. I know we have one judge in my district who will limit the number of judgment and sentencings that he will do on a particular court calendar day. He has a general criminal calendar, and at the end, judgments and sentencings, and he will limit the number because he says this is the most important decision that I make, and it is so onerous, and there's all this preparation ahead of time, and then consideration at the hearing of what the parties say. So I'm only going to do this, and I can't remember how many times each day, but not many, because it is such an intensive analysis. So I'm sorry I can't answer your question any better. I don't have a crystal ball as to how each judge will see this play out, but by having a presumption in order to get at something that the guidelines, we argue, is already doing, because the guidelines already reflect the appropriateness and guide the judge's discretion, exercise of discretion in this way. That we're adding a layer wherever it is in the system, wherever it is in the process, it is going to cause a lot more litigation and consideration.
If I can follow up, just sort of along a similar vein of, one thing that's very helpful for us from some of our witnesses have been real world examples. So we talk about zones and all of that. I know the department was raising a specific concern about zones C and D, 0-point offenders that are not carved out under the enumerated carve-outs for 0-point offenders. Can you give an example of what some of those offenses might be that you think we should be keeping in mind?
Well, so one that really struck me when I read the exclusionary categories was that for covered sex offenses, that trafficking of child sex abuse material would not be covered. That was something that frankly shocked me when I saw it, because we prosecute a lot of child exploitation cases. I can tell you, there's more and more production out there with advances in technology, including just having your cell phone be able to make you into a producer of child sex abuse material. But there's a lot more trafficking too that causes harm to victims. So that's just one example. Another example in the categories is the focus in the violence on the defendant's own conduct makes us concerned that what if the defendant is planning violence with others? And there's recognized in the law of conspiracy that when more than one person gets together to decide to commit a crime, then that crime can be much more serious and can be punished just at the plan stage as opposed to the actual commission. And so that's another one that the department's concerned that a lot of defendants would be swept in and not excluded and potentially be able to, even though the offense level was high, because it was seen as a serious offense, if they're a first-time offender, which a potential terrorist might be, a domestic terrorist or so, or others. There's a certain interplay. I know the commission is considering raising the offense level for correctional officers who are found to have abused prisoners under their care. Most correctional officers have zero criminal history. The commission is also considering what to do with Congress's concern about straw purchasers of firearms, and the firearms then show up in crimes and that. And straw purchasers, by definition, likely have no criminal history. So there's a lot of, there's that interplay too, that if you're raising offense levels for them, but you're creating a category that would then give them a break, then are you really raising the penalty as you think that you're doing? I could go on and on. There's a number of different ones that we think they're serious economic crimes. So serious economic crimes are defined by the impact on causing substantial financial hardship to particular victims. And you can imagine if a defendant defrauds one or two people and takes all of their retirement savings, and the loss is $1 million, that's significant, and that would be excluded from this. But if a similar defendant created actual loss of $1 million, but did that across 1,000 different victims, then that might not be substantial hardship, undue hardship to any particular victim, and so they may not be excluded by the language here. So we may be giving a break to economic criminals where the department has limited resources and in this area, and will do a number of prosecutions in order to create general deterrence among a community of potential white-collar criminals who want to deter from committing these crimes. If they see that someone might go to prison, they think they may go to prison too if they do this. But if we start excluding some of those, then there's less of that deterrence.
Thank you, Mr. Talbot, for your testimony. We appreciate you. We're ready to move on to our next panel.
Thank you, Chair.
Our next panel provides us the federal public defender's perspective on this issue. To present that perspective, we have Jamie Johnson, who serves as an appellate attorney with the Federal Defenders of San Diego. Ms. Johnson previously served as an assistant federal public defender in Arizona, and she has also taught criminal procedure classes at Arizona State University's Sandra Day O'Connor College of Law. Ms. Johnson, thank you for coming. We're ready to hear from you.
Thank you, Chair Reeves. Good morning, and thank you for inviting me to speak on behalf of the federal public and community defenders. Defenders are pleased to support the proposed revisions to Chapter 4, all of which will contribute to remedying the unjustified influence that criminal history plays in determining our clients' sentences. As a public defender, some of the hardest cases we deal with involve individuals who are having their first real encounters with the criminal legal system. Many of these people become involved in the system for the first time because various other systems in their lives have failed them. And as defenders, we see a persistent underutilization of alternatives to incarceration for people who would be better served by services and supervision, including clients for whom prison is likely to hinder rather than to promote their effective rehabilitation. One of the first clients I represented when I became an assistant federal public defender was a teenager who I'm going to refer to as Julio. Julio was a 19-year-old United States citizen who'd grown up entirely in Mexico. He was born prematurely and was intellectually disabled from birth. Tests of his general intellectual functioning placed him in the extremely low range, with serious deficits in the area of memory, learning, and executive function. Julio was raised by a single mother in Mexico after his father died by suicide when he was 10. He was bullied in school, and despite receiving special education services, he never learned to read or write very well. When it became generally known in his neighborhood that Julio had the ability to cross the border, a man from his neighborhood approached him and asked him to carry drugs into the United States. Julio impulsively agreed before later realizing that it would be a bad idea and that he didn't want to do it. But then one day a man showed up at his door and told him that today was the day. He told the man he didn't want to, but the man insisted. And that's how Julio ended up at the San Luis Port of Entry with meth taped to his body. When he got to the primary inspection point, Julio was so visibly nervous that the officer sent him to secondary inspection. In secondary inspection, an officer asked him if he was carrying anything, and Julio blurted out, "I have ice taped to my thighs," before anyone patted him down or called a dog. Julio pleaded guilty to possession with intent to distribute methamphetamine. At sentencing, I asked the judge to impose a sentence that did not involve additional incarceration. The judge, however, sentenced Julio to 21 months in prison, citing, quote, "the judgment of the Sentencing Commission," end quote, in declining to vary further. Notwithstanding a high base offense level, Julio is the kind of person for whom an alternative to incarceration would be most appropriate. He was only 19, and his intellectual disability meant that intellectually and emotionally he was even younger. The psychologist who evaluated him noted that he was impressionable and suggestible, and there were real concerns about the kind of things he was likely to be exposed to in prison and the effect that those would have on his long-term development. On the other hand, he clearly needed services, in particular services for adults with disabilities. And what we found when he ultimately received those services was that Julio did really well. With the assistance of his probation officer, he was able to relocate to the United States side of the border, to rent a room, and to live and work with a degree of independence. He successfully completed supervised release without incident. Julio's story is not exceptional. We regularly see people who get caught up in the system for the first time because something specific has gone wrong in their life, and that thing can best be addressed in a non-custodial environment. Domestic violence, substance use disorders, intellectual disabilities, and serious mental health problems are things that we see regularly. At one point in my career, I represented 2 separate female clients in their 70s with no criminal history, one of whom was taken advantage of because she'd begun showing signs of dementia, and the other of whom was a victim of domestic violence by a grandchild. Nevertheless, even in these kinds of circumstances, we regularly see judges who are reluctant to consider alternatives to incarceration and who specifically cite the judgment of the commission in declining to give the kind of variances that would be necessary to get to a non-custodial sentence. For this reason, we welcome the Commission's proposals that would make it more likely that non-custodial sentences be imposed in appropriate cases. We also welcome the Commission's proposal to eliminate status points, which can have an unduly large effect on the guidelines range, particularly for individuals in lower criminal history categories. Simply being on unsupervised probation for a misdemeanor public order offense is enough to place someone immediately into criminal history category 2. They, in effect, receive twice as many criminal history points for their status as they do for the underlying offense. And a person who's on probation for a misdemeanor offense for which they spent 60 days in jail is immediately vaulted into criminal history category 3, which is the same category as someone with 2 very serious prior 3-point felony offenses. The Commission's own data shows that status points are not reasonably indicative of a likelihood that a person will recidivate, And for that reason and others, we support the proposals to eliminate the reliance on status points in calculating an individual's criminal history score. Thank you for listening, and I welcome your questions.
Thank you. I now turn to my fellow commissioners. Vice Chair Merritt.
Thanks very much, Ms. Johnson. I took very much to heart. I was hoping to turn to the difference between option 1 and option 2 for 0-point offenders in terms of prior criminal history, prior criminal context. I noticed that many of your sort of objections were related to these municipal misdemeanors, and I took very much to heart your description of them and the due process concerns, et cetera. I wondered if we did a third option that said you count as a 0-point offender if you don't have any prior felony convictions of any kind, how much and to what degree, if at all, it would assuage your concerns?
We do not believe that that would be sufficient for several reasons. In particular, one of the things that we have observed is that the distinction between a felony and a misdemeanor is sometimes actually difficult to determine. There are states, Arizona has something called a Class 6 felony that is in fact in the federal system. Following much litigation, we learned that it is in fact a federal misdemeanor offense. And so it can be quite difficult to tell what is a felony and what is a misdemeanor offense. And many states use the word felony for offenses that are federal misdemeanor offenses. And many states make many public order offenses felonies. In Arizona, for example, many simple traffic violations, if done while unlicensed or on a suspended license, become felonies, which in effect means that undocumented individuals who are prohibited from having licenses, who nevertheless drive because they're getting to their job or whatever, who commit what's an ordinary traffic infraction that wouldn't even count for somebody else, suddenly have a felony conviction. So I don't think that simply prohibiting people who have prior felonies or saying we're only going to take into account people who have prior felonies would really assuage our concerns with regards to disparity, even on the point regarding municipal and public order offenses.
Commissioner May.
Thank you. Thank you, Ms. Johnson. We appreciate you being here today and traveling to be here and your testimony very much. So thank you. I had a related question on the criminal history, the no prior convictions. Related to the no prior convictions or comparable judicial dispositions of any kind. I guess I was wondering, if that is read to kind of include juvenile adjudications, tribal convictions, these minor misdemeanors, does that raise issues with disparity in terms of availability of records when we get at that level of prior conduct?
I think that it does. It raises issues of disparity. It also raises issues of practicality. We appreciated the comment by the Probation Officers Advisory Group that records are often very difficult to obtain, and also from the Tribal Interest Advisory Group that tribal convictions don't map easily onto the federal system. As a practical matter, there may be states in which juvenile records can be obtained if they are being used in connection with a subsequent federal prosecution, and there may be states in which they are simply impossible to obtain. And even in cases where they are possible to obtain, it may be unclear in certain circumstances when we're dealing with a very different legal system whether something was a conviction or not because of the availability of alternative adjudications and things like that just raise a lot of logistical hurdles, as well as equity and fairness principles in terms of the disparate treatment of different offenders. And I have a lot of respect for tribal courts. I myself am an enrolled member of a Native American tribe, but tribal courts are not set up or are not required to establish themselves according to principles and methodologies that map easily onto the federal system, and many have elected to have alternative modes of dispute resolution. And it may be that individuals who are members of certain tribes may have very clear records and others may not. And so I think that there would be significant disparity considerations if such offenses were taken into consideration and excluding people from the 0-point benefit.
Thank you. Commissioner Gleason has a question. Commissioner Gleason, you may ask your question if you hear me.
I do. Thank you, Judge Reeves. Thank you, Ms. Johnson, for donating your time and your views. We're very grateful. As you know, one of the things we're considering and have asked for public comment on is an amendment that would implement 994J. And, you know, 994J isn't quite as explicit as it might be when it says the guidelines should reflect the general appropriateness of imposing a sentence other than imprisonment in cases in which the defendant is a first offender who's not been convicted of a crime of violence or otherwise serious offense. And one of the ways it lacks definition is what an otherwise serious offense is. And my question is this: can we rely on the offense table, you know, levels C and D, for example, as a proxy for what an otherwise serious offense is? Is it possible for someone to be a first offender and not have committed a crime of violence or otherwise serious offense and still be in ranges C or D of the guidelines? You understand the question?
I believe that I do, and yes, it is possible for somebody to be in zone C and D and not to have been convicted of something that I think many of us would consider to be a very serious offense. So I think the answer to the question as it sort of originally framed is that no, we don't think that relying solely on the sentencing table as a proxy for what is a serious or not serious offense is fair and promotes the interests of equity and justice. Certainly, the zone on the sentencing table and the overall offense level is one of the factors that the courts will take into consideration in determining whether an alternative to incarceration is imposed or not, and I think that will remain true even if the commission adopts the proposal directing courts to consider alternatives to incarceration. Nevertheless, we routinely, and I'm going to draw on my experience in two border districts here, we see people whose offense level is elevated by factors largely outside their control and often outside their knowledge. And I think in particular, the clients who we see most often along the southwest border are these drug couriers like Julio. They generally agree to transport drugs for a fixed fee that's really a very tiny percentage of the overall value of the drugs. They do not know what kind of drugs are involved. They, in the case of car couriers, which are more common than body couriers, they don't know where in the car the drugs are hidden. They don't know the quantity. They have very little information and are intentionally kept in the dark. These are not people who are members of the cartel. They are people who are, in some cases, being taken advantage of by the cartel, in some cases just in dire circumstances themselves. And so all of these factors that they have no knowledge of, drug type, drug quantity, ultimately become the single largest factor in driving the offense level in those cases. And so somebody who has, the example that always comes to mind is that I think cocaine is about 1/10, is valued about 1/10 the rate of meth on the table. And so somebody who has 50 kilograms of cocaine, we are generally talking about very large quantities because of how things come through the border. 50 kilograms of cocaine has a lower offense level than somebody who has 50 kilograms of meth. And these are identically situated people. Everything that they have agreed to do is the same. And so we see these really high offense levels that are not necessarily appropriately indicative of the wrongfulness of the conduct, of the likelihood that the person would succeed on supervision and be effectively rehabilitated and not reoffend. And certainly there may be circumstances in which the very high offense level is appropriately reflective of the wrongfulness of the person's conduct. And I think we can trust judges to be able to distinguish between those two. But in my experience, we do see a lot of people in zone C and D who are not considered for alternatives to incarceration, where alternatives to incarceration would be very appropriate in their particular circumstances and would benefit not only them, but society.
Thank you, Ms. Johnson. Thank you, Judge Reeves.
All right. Commissioner Wroblewski?
Thank you so much, and thank you, Ms. Johnson, for coming here. I have a couple of questions.
Make sure you speak.
I'm sorry. I have a couple of questions. Do you all, in San Diego, is there an alternatives to incarceration diversion program of any kind in your district?
There are, so I moved to San Diego less than 2 years ago. I'm not aware of an official first offenders court, though or things of that nature. I know that they have some in some districts. I can say with confidence that in Arizona, which had a very similar client profile in many circumstances, especially with respect to border districts, there was a veterans court. There was not a first-time offenders court. They think they're experimenting with a reentry court, but that, of course, would not be a pretrial, an alternative to incarceration program. That's for people who've already served their sentences and are coming out. The Department of Justice is, of course, always free to offer diversion to clients, and we certainly have had clients who have been offered diversion at the discretion of the Department of Justice. Not as often as I would have liked to have seen, and I'm unaware of anybody who was ever offered diversion who was in Zone C or Zone D. It may have happened, but that's not something we regularly saw. We would see that more typically with people who have 0 criminal history points and are already in Zone A or Zone B and have some significant mitigating factors.
Okay. My next question is, I had the privilege of participating in your district just a few weeks ago in a lunchtime training program. Are you familiar? Were you there?
I was not there, but I heard about it and sort of spoke to people in advance about it. So I know what you're talking about.
And the training program is with some of your colleagues, and it was about the First Step Act. And I'm curious, I don't want to put you on the spot, but I'm curious if you're familiar with the way First Step Act earned credit time works, how those are cashed in, because I think there's implications for the 0 point proposal. So I don't want to, before I go on, I don't know if you're familiar, but I have a couple questions about it.
I am.
So the pattern score, which determines whether you're low or minimal risk, is driven a lot by criminal history, it seems to me. I wonder if you disagree with me on any of this, just let me know. And so it seems that it's very likely that the 0 point offenders are going to be minimal or low offenders, and therefore are not only going to be able to earn credits, but are going to be able to cash those credits in for supervised release, early supervised release, or some such thing. First of all, do you agree with that? And then, and if you do, if we reduce penalties for 0 point offenders commensurate with the way the rest of the table works, which is really just one level, what actual impact on the time served would that have on somebody who might have a 21-month guideline, bottom of the guideline range sentence? So instead of 21 months, maybe they would get one level off, they'd get 18 months. What would actually be the difference of how much time they actually served, given that there would be good time credits and earned time credits, and there might be even other credits as well?
So I guess I'll try to answer both parts of your question. And first, I disagree that, I do disagree that the First Step Act earned time credits are going to take care of the majority of these kinds of offenses that I'm referring to. It certainly will take care of some of them. I do not, criminal history is one of the factors included in the earned time credits analysis. In our office's analysis, the actual overwhelming factor, I believe, that was driving a lot of it was age. And so, we see a lot of 18, 19-year-olds who may be at moderate risk. I'm talking BOP level in terms of so backing up a little bit, it's the people with minimal risk of recidivism and low risk of recidivism that are eligible to cash in these earned time credits and to get out early effectively, and people at higher levels are not. And we see people vaulted into higher levels simply by virtue of their age, their pattern score, by virtue of their age. Things like participating in drug rehabilitation program can lower your pattern score, and that is wonderful for our clients with addiction problems. But Julio, for example, does not have an addiction problem, so he's going to be unable to avail himself of that reduction. Simply because he doesn't have an addiction problem to be able to earn that reduction. So there will be many people who will fall, even these 0 point people, who will fall outside the availability of cashing in the earned time credits. With respect to the practical impact, providing a 2 point offense level reduction for people with zero criminal history points will I don't have the sentencing table memorized off the top of my head, but let's say that that's a 6 month recommended reduction in their offense level. With the earned time credits, it would mean, assuming they were eligible for the earned time credits and received all of them, maybe 4 months less on their sentence, just sort of off the top of my head, than they would have otherwise received, which is, that's 4 months in somebody's life. It's meaningful and important to the person who's receiving it.
Yes.
I guess I have a 994J question in particular about the portion of our proposal that suggests that for defendants whose conduct falls into zones C and D, as you know, we've proposed that the test track the statutory language and look to whether the offense is violent or otherwise serious, and the defenders recommend taking out that criteria. And I guess I'm wondering why. It seems to me that there are crimes, I very much take your point that there are crimes that fall in zones C and D, particularly when they're driven by loss amount and things that are not otherwise serious, but aren't there some that are? I mean, one that occurs to me that would not be excluded by the 4C 1.1 criteria is a large-scale fraud against the government, where there's not a vulnerable victim because it's the government. But that seems like, given the, depending on the kind of scale, it could be a serious offense that warranted incarceration. And I wonder if you could say a little bit more.
Sure. So first I would want to situate your hypothetical within the overall framework of who we're talking about when we talk about people with zero criminal history points. I think that economic crimes as a whole are less than 20% of people with zero criminal history points, and that's all economic crimes. And so when you're talking about large-scale fraud against the government, which is a smaller subset of economic crimes, we're really talking about something significantly less than even 10% or probably even 5% of everyone who receives zero criminal history points. I'm guessing large-scale fraud against the government would be a few dozen people a year or something like that. So we're already sort of well outside the heartland of people who have zero point offenses. Large-scale fraud against the government, I'm sure the Commission is very familiar with the fraud guidelines. These are people who are going to be facing a very high offense level by virtue of the loss amount. And so I guess your question actually is as regards alternatives to incarceration as opposed to offense level. So the offense level reduction is going to be really relatively modest compared to the overall very large offense level that will be driven in large part by the loss amount, which would be large in your hypothetical. I would say that in those circumstances that judges are in the best position to assess whether a particular person is in fact a good candidate for alternatives to incarceration or not in those cases. And the judges will, the proposed language regarding 944J that would encourage judges to consider alternative to incarceration is not a mandate. It's an invited variance in appropriate cases and for appropriate individuals. And of course, judges are still going to be required to consider each and every one of the 3553A factors in fashioning a sentence. And so I think that we could leave that to the discretion of the judges to figure out whether certain individuals who have committed, for example, large-scale frauds against the government, whether this is a variance that would be appropriate given the facts of that specific case.
I guess, I don't know if you'd agree with this, but I guess arguably if we chose the maybe appropriate bracketed rather than is generally appropriate bracketed option, that could resolve that concern to you?
I think that is generally appropriate. Is generally appropriate does not mean is always appropriate or shall be imposed. And so again, we're talking about large-scale fraud against the government as a very small slice of the overall 0-point offenses that we see, I think the majority of which are drug trafficking. So is generally appropriate does not mean in every case appropriate. I certainly have not in my career asked for an alternative to incarceration for every client who has 0 criminal history points, and I don't know any defenders who have. So I think that is generally appropriate is language that encompasses the general case and still allows ample room for carve-outs for people whose cases are not general.
Yes.
Thank you for your testimony today and your written submission. Do the defenders have any suggestions for courts who are grappling with this issue under 994J for defining what is a serious offense? Because, I think uniformity is also a compelling driver for the guidelines. And so if the carve-outs that are listed aren't necessarily the right fit, what guidance do you suggest for district judges to determine what's a serious offense and what is not? You mentioned that the zone is one factor, but what would the other factors be?
I think, well, the carve-outs are, would exclude many people just out of the gate, people who have used violence, people who have been a leader or an organizer, people who have used or who have committed offenses that have resulted in serious bodily injury or death. These people are already excluded, and so provide guidance to judges regarding what is a serious offense. I think that beyond the zones, I mean, the 3553A factors are designed to be and are particular to an individual. And so perhaps you have someone who is a 0-point person with 0 criminal history points, but has previously received a diversion or even an informal warning. Perhaps somebody who I'm thinking in cases of white-collar cases who may have received a visit from the government saying, your business practices we do not believe align with the law or with best practices in your business, but nevertheless continue and make no changes to their behavior. So I think that it would be really case-specific and factor-specific, and even, although I appreciate the drive for uniformity, I think that there has to be a recognition that there is some regionalism. I mean, we are in a federal system, we are in a very vast country with a lot of different areas and a lot of different regions, and that having a certain quantity of drugs at the border in San Diego may not be the same thing as having that certain quantity of drugs driving through southern Indiana. That these may implicate different conduct, even though it's the same quantity of drugs and the person both has 0 criminal history. So I think that it would just have to be case by case, and I think that we can trust judges to make this decision.
Any other questions of this witness? Well, thank you, Ms. Johnson. We appreciate your time.
Thank you for having me.
Our 6th and final group panelists will provide us with perspectives on this issue from 4 of our advisory groups. First, we will hear from the Honorable Ralph Erickson, who serves as chair of the Sentencing Commission's Tribal Issues Advisory Group. Judge Erickson served as a district judge for the District of North Dakota before being elevated to the United States Court of Appeals for the 8th Circuit. Judge Erickson has a long history of service on both the state and federal courts in North Dakota, and he has served on state and national ethics panels, including service as chair of the Judicial Conference Committee on Codes of Conduct. Second, we will hear from Susan Lynn, who serves as the Third Circuit representative on the Sentencing Commission's Practitioners Advisory Group. Ms. Lynn is a criminal defense and civil rights attorney in Philadelphia. She teaches in the training division of the Defender Services Office of Temple University, Beasley School of Law, and the University of Pennsylvania Carey School of Law. Ms. Lynn currently serves as president of the Asian Pacific American Bar Association of Pennsylvania. Third, we will hear from Jill Bushaw, who serves as chair of our Probation Officers Advisory Group. Ms. Bushaw serves as Deputy Chief United States Probation Officer for the Northern District of Iowa. She joined the U.S. Probation Office in 2003 and has previously held positions as a sentencing guidelines specialist and as a supervisory and assistant deputy chief in the Pre-Sentence Investigations Unit. Finally, we will hear from Professor Mary Graw Leary, who serves as chair of our Victims Advisory Group. Professor Leary is the Senior Associate Dean for Academic Affairs and a Professor of Law at Catholic University of America. Professor Leary has previously worked in a range of positions in the criminal justice system, including as an Assistant United States Attorney for the District of Columbia, as the Director of the National Center for Prosecution of Child Abuse, and as a Deputy Director in the National Center for Missing and Exploited Children's Office of Legal Counsel. Judge Erickson, we'd like to hear from you whenever you are ready.
Thank you, Chair Reeves and members of the Commission. I'll be quite brief. Ms. Johnson has identified the one issue that TIAG wanted to comment on. We take no position on the proposal generally, only on the use of the language or other comparable judicial dispositions. It boils down to something really quite basic. In those 574 federally recognized tribes, the types of justice that's administered covers a very broad spectrum. We have tribal courts that operate on a Western model, and frankly, they operate with highly trained professionals, at least as good as the state, or at least as well as the state and federal courts do. I mean, they're really just very high-functioning courts, and if we were to score their convictions the same that we do state convictions, it would not matter one jot. On the other hand, we have tribal courts where there's non-law trained judges, non-law trained prosecutors, non-law trained defenders, and they operate on something akin to the Western model, but with very few of the sort of due process considerations that we ordinarily would expect to find. And then we have courts that operate on a very traditional level, right? So you may have a sentencing circle. The sentencing circle is a situation where we have a group of elders sits down with the person who is the victim of crime, with the alleged perpetrator of the crime, and they just talk it out, and they come up with a restorative sentence of some sort, right? And we've had large discussions within TIAG as to what do you do with tribal court history. And we have large debates among tribal judges and tribal prosecutors, depending on where they find themselves in this spectrum, all right? And so what we came up with a number of years ago and what was adopted by the commission at that time was that the whether to include tribal court convictions was left to the discretion of the sentencing judge. And the reason for that is pretty obvious. I mean, if you think about the sentencing judge, the United States District Judge, that judge is fully aware of the courts that are operating on the reservations in their within their jurisdiction, and they'll know how those tribal convictions should be treated. And so broad discretion's given. I'll tell you that, there were 5 reservations that I generally dealt with. There were 2 that I almost always took into consideration the tribal history. There were a couple I never took into consideration, and it was just because of the different models and methods of operation that those courts were using. And when we read the proposal, we looked at our other comparable dispositions, and we thought, well, nobody's mentioning tribal courts. We presume that you didn't intend to change anything relating to how you score tribal court history, but we'd like a more plain and direct statement that we aren't changing anything as it relates to tribal courts. Thank you.
Ms. Lynn?
Thank you, Chair Reeves. Thank you, Commissioners. Good afternoon. I am happy again to be able to provide testimony on behalf of the Practitioners Advisory Group. First, with regard to status points, the PAG endorses option 3, the Commission's proposal to eliminate altogether the assignment of status points under 4A 1.1D. Additionally, the PAG does not support the alternative of applying status points to certain categories of prior offenses, but not others. Status points, as we all know, lengthen a defendant's sentence by driving up their criminal history score and thereby driving up the guideline range. However, as this Commission's own report noted in June of 2022, status points are not predictive of recidivism, and the report did not distinguish among certain offenses or other offenses. Therefore, based on that report, we would support option 3. We ask that the Commission keep in mind that a defendant's back judge or the parole board will have the ability to punish a defendant for a violation of their supervised release or probation or parole. Thus, when we're talking about status points, what is really going on is that an individual defendant is being punished multiple times, or their sentence is being driven up multiple times for what is essentially the same prior conviction. It's being accounted in their criminal history score. It's being counted sometimes, frankly, in the offense level under certain guidelines that are out there, and they're gonna get hit by their back judge. It's not necessary for the status points to exist on top of those things. With regard to 0-point offenders, the PAG welcomes the Commission's proposal this year. The PAG, however, prefers the Commission's proposal that it published in 2016, which proposed a decrease in offense levels for defendants who are true, quote unquote, true first-time offenders, 0-point offenders who have no prior convictions of any kind. The Commission's 2016 proposal provided for a 1 or 2 level reduction in offense level for these true first-time offenders. The PAG previously endorsed the 2016 proposal, and it continues to believe that this is the optimum approach for 0-point offenders with no prior convictions. The PAG's position is based on the Commission's own recidivism reports, showing that defendants without any criminal history have a demonstrably lower risk of recidivism. The PAG further suggests that the Commission incorporate the second option found in the 2016 proposed amendment, which provides for 2 separate reductions of offense level depending on the offense level for the corresponding offense, similar to the Commission's treatment of acceptance of responsibility. In the alternative, if the Commission does not revisit the 2016 proposal, we would push or support option 1, but we would ask that the Commission consider eliminating the 5 criteria points proposed in 4C 1.1A 2 through 6. If any of those factors are present, frankly, they are already incorporated in other guideline enhancements. Just as importantly, the Commission's recidivism studies were not based or did not take into account any of these other criteria. So it's not like a person's recidivism risk rises just because these other criteria are present when they are true first-time offenders. With respect to the Commission's proposal to amend the commentary in 5C 1.1, the PAG supports the proposal regarding Zone A and B. The PAG recommends that the proposal regarding Zone C and D be modified to eliminate the requirement that alternatives to incarceration should only be considered if the conviction is not, quote, an otherwise serious offense, unquote. This qualification would virtually eliminate the possibility for alternatives to incarceration for all Zone C and D defendants because, in the PAG's experience, sentencing judges typically consider virtually every felony a serious offense. Accordingly, the PAG recommends that the comment be modified to state that a non-imprisonment sentence, quote, may be appropriate, end quote, for true first-time offenders in Zone C or D. Finally, simple possession of marijuana. The PAG welcomes the Commission's proposal to provide for a downward departure where a defendant receives criminal history points from a sentence for possession of marijuana for personal use. The PAG, however, believes that treating this issue as a departure may lead to inconsistent treatment across the nation regarding prior marijuana possession offenses. The PAG asked the Commission to consider adding simple marijuana possession convictions to the convictions enumerated in 4A 1.2C1 and let whatever sentence is imposed on such offenses drive how it is treated under the guidelines. Thank you.
All right. Good afternoon.
Good afternoon.
This is my final opportunity to testify before the Commission this amendment cycle, and I'd like to thank the Commission for all of their hard work on these matters the last few weeks and for this meaningful opportunity. Regardless of how the proposed amendments to status points, 0-point offenders, and simple marijuana possession offenses are finalized, POAG commends the Commission's continued review and consideration of the impact criminal history has on determining a sentence that is sufficient but not greater than necessary. Each of the issues we are discussing today all seek to determine if their specific impact on criminal history should be reduced, but through varied means and measuring different factors. POAG's discussion of these issues and the feedback received revealed varying opinions on the matter, but none of them wrong. Status points, for instance, have been the long-standing way to distinguish offenders who engage in the aggravating conduct of committing the instant federal offense while under a criminal justice sentence. It is a fairly common criminal history computation in that it has applied in 37% of the cases, so the feedback that we received didn't garner a significant amount of concern regarding the process or a pressing need for change. But if our system is going to evolve, it requires reassessing factors that are routine, including status points. When I first saw these proposed amendments, it reminded me of a conversation I had when I was a new officer and a defense attorney exclaimed his discontent with the fact that his client qualified as a criminal history category 3 based upon just one conviction. It was a circumstance similar to what POAG noted in our written testimony, wherein a defendant was on probation at the time of the instant offense and had since had that term of probation revoked, providing for 3 points for that offense under 4A 1.1A and an additional 2 points for being under a criminal justice sentence under D, resulting in a criminal history category of 3. Even if the Commission were to adopt option 2, providing for 1 point instead of 2 points under D, the resulting impact of a criminal history category 3 would be the same. This example is part of the reason a slim plurality of POAG members favored option 3, to eliminate status points from the analysis. The underlying conviction scores criminal history points, so the recency of that criminal conduct is accounted for and impacts the total points assessed. Also, it appears the scoring of the status points are not significantly material in determining risk to recidivate or protect the public based on the Commission's recent research. With regard to the 0-point offenders, while we do favor the idea of conferring a benefit to those offenders who pose the lowest risk of recidivism, that was generally agreed upon by POAG, that this is something that should be addressed. We were unable to reach a consensus regarding the proposed amendment, largely based upon the several factors that need to be considered under Chapters 2, 3, and 4 before the reduction would apply and then only apply to a narrow class of offenders. One application POAG identified with option 1 was the criteria that the defendant had no prior convictions or other comparable judicial dispositions of any kind. The guidelines have always focused on more recent convictions, meaning the records that we need are available to determine the scoring. This amendment would immediately make really old records essential and relevant. An indication that a defendant had a prior arrest 20 to 30 years ago becomes relevant. We would need to do our due diligence on every old criminal history entry to confirm if there ever was a conviction, which can be especially a difficult process when it's a juvenile disposition. Further, as indicated in our written testimony, some of the factors under this guideline, such as limited criminal history, no firearm or violence, and no aggravating role, are similar to the factors assessed in relation to safety valve, meaning they would be eligible for a second reduction based upon duplicative factors. POAG believes that the criminal history for these types of offenders in the appropriate case is already a 3553A factor the court considers in determining the appropriate sentence. And we further believe further research into alternatives to incarceration, including expanding the sentencing options within the sentencing table zones, could be potentially the vehicle used to address the types of offenders this 0-point offender amendment is intending to capture. And finally, with regard to offenses for simple possession of marijuana, the feedback we received favored addressing this issue by way of departure under 4A1.3, if needed, given that the issue is continually evolving and determining if a prior offense for marijuana is no longer subject to penalty in various jurisdictions isn't always an easy analysis. Further, we would note that possession of marijuana has not been legalized federally, and marijuana use remains an issue our courts address in relation to supervised release violations. Thank you.
Thank you. Ms. Leary, I apologize.
Nope. Thank you, the VAG, once again. Thanks the Commission for inviting us to speak to you on these issues, and to echo the comments of Ms. Bouchard, thanks you for all the hard work, obviously, the Commission has put in and your stamina over these 4 hearings. The VAG has limited comments focusing on status points and 0-point offenders. We oppose both proposals and find them in tension with all of the purposes of sentencing, but I want to start first with our comments on 0-point offenders, because that will expand much as to what we provided in our written testimony, and then if there's time, I'll return to status points. The best way to consider the Victim Advisory Group's position is first principled and second practical. And principle, the VAG is concerned with the amendment's effect, which is to essentially create a new category and a reward for a convicted criminal defendant for doing what is expected of every citizen, to obey the law. Now that may be overly simplistic, and the VAG does understand the distinction the Commission is trying to draw between true 0-point offenders and offenders who have prior convictions. But the VAG's view is that if a convicted defendant has no criminal history, that's already calculated into the applicable sentencing rate. It's already a part of the consideration for the court. And to get another bonus, a new special category, because thank you, you haven't victimized people before that we know of, the VAG feels goes too far. But on a practical level, the VAG has other more specific concerns. The Commission bases its extremely sweeping change to the guidelines on its finding that 0-point offenders have, quote, lower recidivism rates than other offenders, including those in criminal history category 1. And the Victim Advisory Group shares the observation of the Department of Justice that that is an insufficient basis for such a sweeping change to the guidelines, affecting over 13,000 offenders, and that would mean thousands of victims in those cases. Some of it's all to whom you compare, and yes, compared to other federal criminal defendants, this group has a lower recidivism rate. However, they still have, to the ordinary citizen, a high recidivism rate of 26.8%, and as the Department of Justice pointed out, 41% of violent offenders with 0 points are rearrested within 8 years. But more troubling to the Victim Advisory Group is who will receive this benefit. We noted the demographics of some of the defendants who will receive this benefit in our written testimony. We've mentioned people who are child sex offenders, but there are other types of offenders that the Department of Justice discussed in their written testimony. From a victim perspective, it bears noting that many of these offenders are in a position in which they can offend for the very fact that they don't have prior criminal histories. They exploit the fact that they have no prior criminal history, so they can be employed as police officers, prison guards, scout troop leaders, school principals, and that gives them access to victims in order to harm them. And then, if they are caught, tried, convicted, and sentenced, they can again exploit that category to have less of a sentence. And the VAG finds that concerning But most concerning is the language in the opinion, the language in the guidelines that seems to exclude child sex abuse material possessors, traffickers, and receivers from this category of covered sex crime. This is extremely alarming to the VAG, and it flies in the face of over 30 years of Supreme Court jurisprudence on this issue. In 1982, the Supreme Court said in Ferber, child pornography poses an even greater threat to the child victim than does sexual abuse or prostitution. Because the child's actions are reduced to a recording, the pornography may haunt him in future years, long after the original misdeed took place. A child must go through life knowing that the recording is circulating within the mass distribution system for child pornography. From its inception, the Supreme Court has recognized this is not a victimless crime. But if there's any confusion about that, the court clarified that in 2015 in Paroline versus the United States, where it underscored this and shut the door on that assessment, saying that it is, quote, it is common ground that the victim suffers continuing and grievous harm as a result of her knowledge that a large, indeterminate number of individuals have viewed and will in the future view images of child sexual abuse that she endured. The court went on to say, in a sense, every viewing of child pornography is a repetition of the victim's abuse, and such possessors, quote, such possessors' conduct produces concrete and devastating harms for real, identifiable victims. And the court closes saying it would be inconsistent to apply the statute in a way, the child pornography statute, the restitution statute, in a way that leaves offenders with the mistaken impression that child pornography possession is a victimless crime. And given that, the VAG's strong view is under no circumstances should that be excluded from the types of crimes that severely affect victims. I have other comments about status offenders, but I await questions. Thank you.
Thank you, Professor Leary. Any questions? I have one, Ms. Leary. You wanted to have time on your status points. That's my question.
Thank you
Right.
very much, Commissioner. But, essentially, our view is simply this, that a defendant's criminal history is directly relevant to all the purposes of sentencing, not just one. I mean, again, I state the obvious, but if one has status of points, they are a recidivist, and that certainly is relevant. And part of the criminal history, a part of a defendant's criminal history is if he commits a further crime, well, he's literally either serving a sentence, on probation, on parole or supervised release, in prison, on work release, or escape status, and that certainly, we think, indicates his offense or her offense is more serious. It certainly indicates that for general deterrence, this would be very important. It certainly indicates that the defendant is not amenable to rehabilitation. So it is the victim advisory group's view that the research does indicate that it may have something to do with recidivism. However, there are other sentencing guideline provisions that are not affected by this, and to have such a sweeping change, we feel is not sensitive to the victim experience. Thank you.
Thank you, Ms. Leary. Any questions from my fellow commissioners? Commissioner Wroblewski.
Thank you so much, and thank you all for being here. Judge Arison, is it okay if I ask you a question on just your role as a judge rather than as a tribal?
Sure.
So, if the commission goes ahead with a proposal dealing with 994J that we were talking about before, so we would say that even if you're in zone C and D, that a sentence of probation, and we've had lots of different iterations, may be appropriate, generally appropriate, we've also heard. Do you and let's assume we have a hypothetical where there's a Medicaid fraud defendant who stole a certain amount of money and their guideline range was 60 months, so they're in zone D.
Mm-hmm.
Do you think that among your district court colleagues in the 8th Circuit, that they would apply that provision, that sort of separate little provision about probation after going through all of the guidelines calculations and figuring out loss and litigating role and all the rest of it, and then they get to 60 months? Do you think they would apply that consistently?
I believe that they would do a much better job of applying that consistently than they would a variance downward. The reality of it is that if it's authorized within the guidelines, there's a sense of security in imposing that sort of sentence, and that's that there will be greater uniformity. This is a quick aside. One of the issues that we've got right now among our district judges is that there are variances being imposed rather than guideline departures because nobody knows really how it's going to be treated, and they know that the appellate courts are going to say, well, we know they considered everything, and there's no procedural error in it because it's variance, and so and that undermines the guidelines. And so I think if we can give clear guidance on when the departures are available, how they should be considered, that judges are more likely to use those types of departures, and that will actually bolster the guidelines so they're not constantly being undermined by well-meaning district judges. And I confess to having done it myself a couple of times in my life, and I think that's good for the system as a whole.
Okay, thank you. And then one last question. Do you think that there's anything for us to learn on the Sentencing Commission from sentencing circles?
Oh, I do. I gave a speech at a listening conference in Bismarck, I must be almost a decade ago, where I said that really if you think about the contributions that have been made to our judicial system by a conquered people, that you have the same thing available with the tribes. If you think about it, is that the Anglo-Saxons are the basis for much of our common law, but overlaying it is Norman law that was imposed by a conquering nation, right? And yet the amalgamation and the synthesis of those two systems has created a much stronger judicial system than existed in either the Anglo-Saxon common law tradition or the Norman legal tradition, right? And I think that the sentencing circles have the same ability to instruct us on what might be appropriate in a restorative model, right? I mean, I think there's something really, I could give speeches for hours. I don't mean to do that, but you got work to do. But just think of this. In one of the tribes that's in our state, traditionally there were only two penalties. You sat at the circle with the elders, with the person who was victimized by the crime and the perpetrator of the crime, and they talked it all out. And at the end, the tribal elders would make a decision. And there were only two available penalties. One was banishment, which was a sure and certain death sentence, because if you were banished on the northern plains, there is no way that you could support yourself, feed yourself, clothe yourself without some other group picking you up. Now, occasionally another tribe would accept one of those people into their communities, but usually they'd say, yeah, if your own people don't want you, we don't want you, right? Or you would have a situation where, for example, if I murdered another man, his widow and children would be required that on the sentencing circle they'd say, yeah, you're going to support those people because you're going to provide the first kill of all your hunting expeditions. You'll provide for the family that suffered a loss first, right? And so that man might end up supporting two separate families in that model. But I mean, I think obviously murder's not a thing that we do sentencing circles with, but I think that the idea that out of that there is wisdom because the community heals is an important idea,
Yes.
Actually, I have two questions. My first question is, thanks, by the way, to this fabulous panel. My first question is for Ms. Lynn. I wonder if you could say a little bit more about why AG prefers the 2016 proposal to option one. Is it that there is a tiered level of reduction? Is it the lack of exclusions?
I think it's the clarity coming from the lack of exclusions. I think the 26 proposal really is tied directly to what the studies show, which is just plain old a significant drop in recidivism risks for people who are true first-time offenders. There's also a drop in recidivism risk compared to those with one criminal history point for those with 0 criminal history points, but they have priors that aren't scorable. The PAG does advocate these reductions for the true first-time offenders solely based on the number, the extreme drop in recidivism risk. 2016 is more clear.
Thanks. My second question is for Ms. Leary. Mr. Leary. I wondered if you had any thoughts on the 4C 1.1 exclusions, and in particular, I mean, some of the exclusions in there for, a violent defendant where the instant offense involves violence or resulted in death, or where there's been it's caused a substantial financial hardship to the victim, are geared to minimizing victim impact. And I wondered if you had other suggestions for how we should craft these. I assume you may have suggestions about the sixth one about covered sex crimes. You covered that a little bit, but I'd be interested in your thoughts on A, how to craft six, and B, if you had other thoughts too.
Thank you. I'm going to take the question in terms of discuss the VAG as yesterday, discuss with the VAG. One of Commissioner Reeves' questions also requires me to speak to them to suggest some crafted language, so I will. I would say first, we do appreciate the effort of the Commission. I think trying to draw that distinction between crimes that do significantly impact victim survivors and those that do not. But we do also share the observation of the Department of Justice that victims aren't only in front of us bleeding, right? You know, that if there's a massive fraud, that can affect people in significant ways as well, sort of that the non-immediate victim survivor. So I'm going to take your question, if I could, Vice Chair Murray, and go back to the VAG and ask them to make some suggestive language for you on that. Again, we, as you can tell, got a little bit upset about one in particular. That my job was to convey that. Thank you.
Any additional questions from this panel? I assume it pays to be last. I believe that concludes everything. So we'll bring this final day of testimony on this whole thing that we've been considering over the last couple of weeks. We've heard from some great panelists. We've gotten a lot of comments, over a couple of thousand now. I expect to get more. I appreciate the effort that everyone has put into this process. This process is important, and I deeply appreciate everyone. And I'm talking to the people who are listening in, who are watching. I'm talking about the people who testified back in February. I'm talking about the many sacrifices some of them really, really made in giving us the information that we needed, that we requested, that they participated in. I'm talking about everyone who's participated on any level. We just appreciate you. And I can promise you, we're going to take all that information. We've been taking it in. We've been talking, we've been listening, we've been trying to figure this out. Nobody's testimony, nobody's comment is being overlooked. It is being taken in. We're trying to balance what the various persons and groups are saying. We want to get to the right decision. We want to get to the just decision. We want this process to be better. I can say that. I mean, we really want this process to be better. So I thank every panelist. I thank every staff member. I thank the public. It's the public who makes our system work. The public, the judicial system, if you will, just does not get the attention normally that the other branches get, because we operate in a system where people just don't know much about it and they don't understand it. But our system works better when we have eyewitnesses. That's my view. When we have eyewitnesses, people who want to see the process work, people, the public being involved. And I do thank the public for being here. So we've heard your testimony, we're considering your testimony, and we will indeed use this testimony and these comments to make our sentencing policy, to make it right, to make it fair, and to make it just. And I thank each one of you for all that you've done to help us get to that point. This hearing is now adjourned. Thank you so much.